Yes, we had a couple of meetings in this regard, including the representatives of AIMS and the
Correct.
medical this one, and also my friend Mr. Datar also was there. After deliberating upon, we have shortlisted or come down with the particular proposal under which the interest of both the parties, like the person who is going to do it, and also his safeguards that have been deliberated upon, and we have prepared a chart. I think my friend Mr. Datar will be able to.
Advance directive where a person makes a declaration, he should not be put to invasive treatment.
Passive euthanasia.
Yes.
Something like passive. Something like, that's why I said that.
Yes, yes. So where the person, his own volition says that he doesn't want invasive treatment, where the chances of his, so what, Mr. Dr. Kishore is here. Now,
Doesn't amount to judicial legislation of this.
No. But what happened was, initially the high-tech bench laid down certain directions as to how to do the advance directive. That required going to multiple courts, recording the matter before judicial magistrate.
Para 198.
Then, yes.
Para 198.
Yes, para 198. First, three-step process, very cumbersome.
There are actually the 4 judgments written. So, there's Deepak Mishra with whom Justice Kanvilkar can agree.
Yes.
Then the other learned judges also wrote separate concurring judgments.
Yes.
So, where do you get the view of the court as such?
No, everybody concurred with the guidelines. Ultimately, we only worried about the guidelines.
Only on the
Yes,
reasoning.
on the reasoning.
They wrote separate. They wrote 191 that the process by which you go to there will be 2 boards. First the board certify, then it has to go to the collector constitutes the chief medical officer, another board, the magistrate goes, attests it, and so on and so forth.
What happened was,
It can be challenged in a repetition if it is refused.
yes.
And it goes on like that.
The legal issue involved in that matter is already settled in that judgment. Now only the procedure how it has to be done, that is the only thing to be deliberated upon.
After the guidelines were issued, the entire medical community, we discussed number of hospitals, it became unworkable. For a person say in Chennai or in Bombay or in Delhi, now it's difficult to go to a judicial magistrate, record it, and then when the time comes, another board has to be constituted. So then we said it's not going to work out. And then based on your lordship's suggestion, we had multiple meetings and so on. Now there are 2 parts. One is how the advance directive should be recorded, point number 1. That Mr. Kishore will address, Dr. Kishore will address.
Who are the parties in this repetition? One is you.
The Indian Society for Critical Care. Now, one is the recording of the advance directive. Now, when the advance directive is recorded, there has to be some safety in recording the advance directive. This note which I am giving you, this is a note post the advance directive.
Yeah.
But this note that I am giving, with this chart which I am giving, is post advance directive. As far as advance directive is concerned, Dr. Kishore he has discussed the law from Oregon, Montana, etc. What are the safety? Because it can be manipulated. Somebody can say a false advance directive, and then, because once the patient goes to hospital, and if he's in comatose condition or in the critical condition.
Why don't you just read for the benefit of the bench?
Yes.
Exact advance which you want to be supplanted, changed.
Yes.
Let us just read that.
No, what we are saying is, once the advance directives are, your lordship approves the method of recording, it should be videographed, should it be by a smartphone, because we're talking about a large country like India. Now, one method is I can put it in my will. The person can put it in the will and tell his king that when the time comes, don't have any invasive treatment. I spoke to the senior doctor from AIMS also, and the lady also told me that many people who come with terminally ill illnesses, they tell the doctor that, look, I've lived a full life, I'm well past 89, 89. Please don't put all these tubes, etc. And that's what she has also. So there is a form which AIMS has got. Now, Milord, there are 2 parts. He address on advance directives, I will come to that later. Once the advance directive is is agreed upon, then what is the step to be followed? Once there's an advance directive, then the question of getting the consent of the next of kin doesn't arise, because the patient on his own volition has given, for the time being, a valid advance directive that I don't want invasive treatment. Now, basically, before going into it, just broadly what we discussed with the health ministry and what we came and want to place the.
We want to again ask you, the only parties are the government of India and this common cause. That's all.
That's the original petition.
Who are the parties?
Now Indian Society for Critical Care Medicine.
Okay, is it a party here?
It's an intervener.
It's
They are
an
the
interview.
Yes, we argued matter the last time.
They have the applicants.
Yeah, the applicant. And we argued the last time.
I think you are representing common cause. The original petition.
No, actually, I'm representing Indian Council for Critical Care Treatment.
So who appears? Who is that? So what is your view?
We are supporting it.
You are supporting them.
It's a very well known, very good organization.
Very good.
No, and I spoke to surgeons from leading hospitals in Madras and Bombay. Actually,
No.
and also AIMS.
Now let us just run through quickly the procedure which is prevailing as of today under the order.
Yes.
Let's just take us through that. So then, we can immediately apply our minds to it and then.
And perhaps, Mr. Doctor,
Yes.
you use the word will. This is during the lifetime of the person and is to be executed while he is still alive. So therefore, we have to have a proper word for the document that we are looking at.
Yes.
Living will is one of the document that is, that's one of the common phrase that is being used. Whether living will or some other
No, there are
phrase.
two phrases, living will and advance directive.
Okay.
Because,
Living will also has a certain connotation. Perhaps that could also be one of the things.
But my-
Advanced directive is
I
a,
also in most legislation, as Dr. Kishore will point out, they're using the word advance directive. That is, in advance, I give a directive that when the eventual time comes, the person should not be put to agony, etc. Because what happened was, it's very difficult for the people who are his family to take the difficult decision.
Very, very difficult.
Take him out the- And as your Lordship lastly pointed out, it can lead to financial ruin also, but the parties can't take a call. So
Straight away, we will come to the actual.
actually, what is the portion first?
What is the portion first?
What are the original guidelines?
What are the changes that you would like to
Yes.
incorporate? So let us just have a look at the.
Lord, before your lordship, I want to make a brief submission.
Mike.
But he has been instrumental in drafting the Medical Termination of Pregnancy Act, and his articles have been referred to by his Lordship. Yes, he speaks with some authority.
Lord, I was a doctor for 40 years, since 1968 till 2004. Then I diversified into law,
What is your area of specialization? Medical field?
radiology,
Okay, as a diagnostic too.
diagnostic as well as therapeutic radiology.
Both.
When I did radiology, at that time it was one.
Yes.
Later on, it split into two, therapeutic radiology and diagnostic radiology.
And even there is a lot of specialization.
And in therapeutic radiology, there are some specialties.
Abdominal, you have all.
And in the diagnostic, there are about 20 subspecialties.
Absolutely.
Neuroradiology, gastroenterology, hepatology.
That's right.
My subject was hepatology. So, my lord, I have been a lawyer for the last 18 years, practicing in this honorable court. And I am associated with this issue right to in life for a quarter of century. My first article appeared in 2005. And I have gone through the judgment given by his lordship, Honorable Justice Deepak Mishra. And there also I was an amicus in that case.
Very good.
Now I have made a small brief in which everything is there. These are the 5 sets. Right from the concept, what is the moral concept, what are the legal challenges, and how different jurisdictions of the world have ensured any kind of abuse or misuse of this particular notion. So the first law came in 1997, the Oregon Death Dignity Act. That was a statutory document, which for the first time recognized a person's right to end his life. Thereafter, about
asking the question
Yes.
as to what is the legal bar if a person refuses to actually receive treatment and says, I don't want any further treatment.
Yes,
So is there a legal bar in law or even otherwise? Is what he
Yes.
there are three legal paradigms.
Because we are conferring legal right to refuse treatment, but what we are exploring is there a legal bar in refusing treatment? Because every time a near and dear one is taken to hospital, we have to sign all kind of
Documents.
bonds.
So, my lord, on this particular issue, right to die. Right to die is a very well defined issue in the global context.
It's not right to die in normal situation. It is right to die when very ill.
That's why in this case also,
Circumstances.
this case also, they have dealt with the nurses and dealt with right to live with the dignity and right to die with the dignity. That was it.
There are two kinds of persons on the planet. One are those who add years to their life. Others are those who add life to their years. So the moral paradigm,
That is a philosophical moral paradigm. We are asking where is the existing prohibition?
my lord,
Just one second,
just let me complete. My lord, there is only one country in the world, that is UK, which have British Suicide Act 1961.
We are not on suicide. Somebody is suppose very ill.
Yes.
Now, if he is taken to the hospital, he may give an advance directive, don't put me in a ventilator.
Yeah.
But if he chooses not to go to a hospital, what happens then?
That is very well settled. This whole constitution bench judgment say that everybody has an indefeasible right. If he is in his right mind, he has an indefeasible right to refuse any treatment.
Yes.
He cannot be forced to take any treatment. Here the question only arises, if a person is unconscious and he is incapable of expressing his will as to whether he wants to be continued, whether he wants to be put on a ventilator or not, then the question is, if such a person in advance says very critically he goes to a hospital, he knows that he may be put on a ventilator. He gives a advance directive saying that, look, should this situation arise, I don't want to be put on a ventilator. I don't want to be kept alive by artificial life-saving means. And he signs that declaration and gives it to the hospital. Then the principle
Normally, right now, the next of kin has that authority
so that
to say whether to put into the ventilator or
the
not.
next of kin's
You
right,
want to shift it to the person concerned.
if the person concerned has given an advance directive, then it overrides the right of the next of kin, because he has an indefeasible right to decide what should be done with him. And if in his right mind he has given an advance directive, then nobody, not even his next of kin, can force him to be put on a ventilator, even if he becomes unconscious. That's the whole object of this advance directive or living will. That nobody, not even his next of kin, can force him to be put on a ventilator. Now, the problem that has arisen, because of which this application has been filed, is that unfortunately, my lord, the court, while giving legal status to this advance directive and saying that it should be honored, has put a large number of very cumbersome restrictions as to how that living will has to be executed before a magistrate, this, that, and the other, which are unnecessary. So that is why this application.
When you are seeking clarification, it's not better to go to 198 so that we can,
Yes, but I will.
what exactly are the,
In fact, we are about to go to that, but to answer my lord, just those questions, please see page 11. AIMS has got a form that patients wishes for withholding life support. This is even done today, page 11 of this spiral bound compilation. So that will answer my lord's question. That today, I mean, without advance directive, etc., I may not, but when I'm going in for this, but we've got enclosure 2, page 11. All in all.
Yes.
What section got it?
So
Yeah.
under what law is this given?
The law in India.
There is no statutory provision saying that in extent.
Yes.
There is no statutory.
So why if it's otherwise permissible and
Common law, yes.
why are you
No.
requiring advance directive from us?
No. This is a signature by the patient who is conscious. See, I with so and so, I could have a critical terminal illness where the disease modifying options are no more applicable.
Plus the hospital is conscious.
No, what? If I said so.
We have reached that stage.
Just because I put advance directive has to be obeyed. It still goes to the primary board, then it goes to a review board, because I'm completely unconscious. I'm not in a position, and I'm told by doctors that very often a person is terminally ill, he's not able to fully think rationally.
The better course is let us see 198.
Exactly, that's what he is telling you.
Where is
Please
the-
go through, let us go through one
Yeah,
ninety.
become impossible to work out.
And that is the only area where we have to come in, otherwise it's a judgment of this.
So far as law is
They
concerned,
are seeking
so far as law is concerned, this judgment itself makes it very clear. Till appropriate legislation is made, this has to be followed.
Exactly.
That's what it is.
Still also what is
Living in a gap.
Yes.
No, after this judgment came, we read out to the next constitution bench saying that some of these paragraphs are not workable. Then they asked us to go back and come with alternative suggestions.
That's how you are here.
That's how we are here.
Therefore, let us
And
start.
since the 5-judge bench, only a 5-judge bench.
Let us read 190.
Yes.
Otherwise we are just,
Page,
that's why we,
who can execute advance directive and how?
at page 129.
129 starts at 198. Yes, but now, just to tell your lordship, to save time, your lordship will tell me what to do, I'll follow that. 175.1 is the first question.
Where you are reading?
198.1, now there are multiple.
Exactly, we got 198 points.
Yeah, just see 19, the first question, who can execute the advance directive and how? Now, just before coming to that, please come to the next question at page 1, just a bird's eye view, then I'll come back to individual questions. Come to page 176. What should it contain? Then that is discussed. Then 198.3, how should it be recorded in full?
So we are 170.
176 is who can execute the advance directive.
You are reading not from, we are reading the SEC.
Yes, I'm also reading SEC.
You are reading not from a.
Okay.
That's
But I've got para 198 is there, Bharat?
Para 190.
Does it start with the word in our considered opinion, advanced
That's
medical
right.
directive should
That's right.
serve as a fruitful means?
You
to-
want us to read 198.1 that we have got.
Yes, then if your lordship just comes to 198.2,
Correct.
what should it contain?
Correct.
All your lordships have seen that?
Yes, we have seen that.
Then 198.3, how should it be recorded and preserved?
Correct.
Then 198.4, when and by whom it should be given effect to.
Yes.
Now, what we are given today is 198.4.
So we need not be concerned with other aspects.
No, your lordship has to be concerned because.
It's the earlier part
So
also.
first is recording of the advance directive, because as the Solicitor General also mentioned, lordship also put it, we should have some safeguards on this potential misuse for purpose of property or other disputes, etc. So the advance directive, which is
Has there been any empirical study after the judgment as to how many persons have actually made use of this?
but I am told that AIMS form has been.
Doctor of India actually,
No.
does it contain any?
No.
Because you may go to a private hospital, you may go to a government hospital, of course, but the governmental authorities are involved, magistrate and the DMO in terms of this. So you would have statistics of the practical value of this, this
No, there's only anecdotal evidence, no empirical evidence.
no evidence.
As of now, there is no empirical evidence.
Actually, what happened is the directives from day one could not be implemented because it was not possible to go to the magistrate, get his permission and so on.
Because of cumbersome procedure that is now presently involved.
Absolutely.
Yes, that is the one which has to be.
My colleague tell me that persons who went, they were refused because they say we have to follow all the entire procedure. It's not possible.
Better we go through it. and
What-
find out.
198 we can start with.
186, what is actually this
186, Baba?
186 says what actually is advanced
Yes,
directive.
Black's Law Dictionary.
What actually is that?
Very well.
In
Very
what
well.
manner this term was understood by the.
But I will start with para 184, which starts with subheading capital P. advanced directive, advanced care directive, advanced medical directive. Has all your got that? Because yes. In order to overcome the difficulty faced in case of patients who are unable to express their wishes at the time of taking the decision, the concept of advanced medical directives emerged in various countries. The proponents of advanced medical directives contend that the concept of patient autonomy for incompetent patients can be given effect to 184.
Yes, yes, you continue.
All your workshops have got it?
Yes.
The proponents of advanced medical directives contend that the concept of patient autonomy for incompetent patients can be given effect to by giving room to new methods by which incompetent patients can beforehand communicate their choices which are made while they are competent. Further, it may be argued that failures to recognize advanced medical directives would amount to non-facilitation of the right to have a smooth dying process. That apart, it accepts the position that a competent person can express his or her choice to refuse treatment at the time when the decision is required to be made. Advanced directives for healthcare go by various names in different countries, though the objective by and large is the same, that is, to specify an individual's healthcare decision and to identify persons who will take those decisions for said individual in the event he is unable to communicate his wishes to the doctor. Black's Law Dictionary defines advanced medical directive as a legal document explaining one's wishes about medical treatment if one becomes incompetent or unable to communicate. A living will, on the other hand, is a document prescribing a person's wishes regarding the medical treatment the person would want if he was unable to share his views with the healthcare provider. Another type of medical directive, advanced medical directive, is medical power of attorney. It is a document which allows an individual to appoint a trusted person, agent, to take healthcare decisions when the principal is not able to take such decision. The agent appointed to deal with such issues can interpret the principal decision based on their mutual knowledge and understanding. Advanced directives have gained lawful recognition in several jurisdictions by way of legislation and in certain countries through judicial pronouncements. In vast majority of states in the United States, it is mandatory for the doctors to give effect to the wishes of patients as declared by them in their advanced directives. California was the first state to legally sanction living will. The United States Congress in 1990, with the object of protecting the fundamental principles of self-autonomy and self-determination, enacted the Patient Self-Determination Act, PSDA, which acknowledged the rights of patients to either refuse or accept treatment. Following this, all 50 states enacted legislations adopting advanced directives. Apart from this, several states of the USA also permit patients to appoint a healthcare proxy, which becomes effective only when the patient is unable to make decisions. In order to deal with technicalities and
Advanced medical directives is well recognized
yes,
and acceptable.
yes,
Now we have to put it in how we have to implement
yes,
so that this all safeguards must be there.
yes.
Now come to 198 and see what are the safeguards provided
All right.
and according to what safeguards require modification.
Now, Lordship will kindly come to 198.
That's correct.
Yes. Lord, I will just, with your permission, read the earlier paragraph that will give a flow to the 198. Having dealt with principles in vogue across the globe, we may presently proceed to deal with the issue of advanced medical directive, which should be ideal in our country. Be it noted, though the learned counsel for the petitioner has used the word living will, yet we do not intend to use the same terminology. We have already stated that safeguards and guidelines are required to be provided. First, we should analyze the issue of legal permissibility of the advanced medical directive. In other jurisdictions, the concept of living will and involvement of attorney are stipulated. There is no legal framework in our country as regards the advanced medical directive, but we are obliged to protect the rights of citizens as enshrined in Article 21. It's our constitutional obligation. As noticed earlier, the two-judge bench in Aruna Shanbhag has provided for approaching the High Court under Article 226 of the Constitution. The directions and guidelines to be given in this judgment would be comprehensive and also cover the situation dealt with Aruna Shanbhag. This is that nurse who was comatose for 28 years. Okay. In a considered opinion, advanced medical directive would serve as a fruitful means to facilitate the fructification of the sacrosanct right to life with dignity. The said directive, we think, will dispel many a doubt at the relevant time of need during the course of treatment of the patient. That apart, it will strengthen the mind of the treating doctors as they've been in a position to ensure, after being satisfied, that they are acting in a lawful manner. We may hasten to add that advanced medical directives cannot operate in abstraction. There has to be safeguards. They need to be spelled out. We enumerate them as follows. Number one, they start. Who can execute the advanced directive and how? The advanced directive can be executed only by an adult who is of a sound and healthy state of mind and is in a position to communicate, relate, and comprehend the purpose and consequences of executing the document. It must be voluntarily executed and without any coercion or inducement or compulsion, and after having full knowledge and information. It should have the characteristics of informed consent, given without undue influence or constraint. It shall be in writing, clearly stating as to when medical treatment may be withdrawn, or no specific medical treatment shall be given. It should only have the effect of delaying the process of death that may otherwise cause him/her pain, anguish, and suffering, and put him/her in a state of indignity. What should it contain? It should clearly indicate the decision relating to the circumstances in which withholding or withdrawal of medical treatment can be resorted to. It should be in specific terms, and the instructions must be absolutely clear and unambiguous. It should mention that the executor may revoke the instructions authority 3 times. It should disclose that the executor has understood the consequence of executing the document. It should specify the name of a guardian or close relative who, in the event of executor being incapable of taking a decision at the relevant time, will be authorized to give consent or refuse or withdraw medical treatment in a manner consistent with the advanced directive. In the event that there is more than one valid advanced directive, none of which has been revoked, the most recently sent advanced directive will be considered. It's more like
Like 190.2.1, just can we revisit it?
it should clearly indicate the decision relating to the circumstances in which withholding or withdrawal of medical treatment can be resorted to.
So this is a central kind of thing.
Oh,
Correct. We're talking about a country like India. The masses across social, economic status. So you've got to apply it. You take, for example, a disease like cancer. You can broadly categorize it final stage, terminal cancer. Now, what if somebody says that if I am afflicted with cancer, I don't want to undergo treatment. Side by side, place side by side, the fact that, by the time he comes into that state, huge advances are made. In fact, it's happening on a day-to-day basis, trials and different kinds of treatment. So, he says, I don't, if this happens, if cancer comes, finish. It's not whether it's primary, it's secondary, whether there is metastasis, nothing. He simply says, somebody says that.
it's a trigger.
He says a trigger, and he says, irrespective of whether it is terminal or whether it's treatable, he says, I don't want it. Because he's been told that cancer, and if I don't want it. He's got the freedom, he's got the choice, it's my life. But are we not, in that sense, devaluing the value of life itself?
No, that your lordship's concern is addressed by the question that the personal decision is not the be all and end all. It says that if I'm afflicted with cancer, first of all, it should be a cancer where you reach the stage where doctors, we have seen all our relatives.
But does it say that?
No. We have
Does
seen
it, what should it contain? See, the point I'm trying to make.
No, I'm just coming to that. No?
Yes.
Just sorry to interrupt. What happens is this, first of all, there's an advanced directive that should it come, typically they will say if I'm afflicted with a disease, which is difficult to cure or where the chances of recovery are remote, because today when a person makes advance, he does not know what he's going to be afflicted with. It could be, for example, who thought of corona?
I do it at the age of 30 years.
Yes.
Supposing I see it and I am fed up, I don't want treatment. I do it at the age of, say, 30 years. Okay, I don't touch it. So I become afflicted by, say, about 25 years. The state of the medicine.
Maybe.
Is
That's why there is a
completely transformed.
No, that's why there is a medical board. What we have contemplated is a primary board, which says that look, no, this man can be treated, and that primary board contemplates an ethics committee which the health secretary wanted to add, which is there. Then after the primary board, there is a review board, and the review board can also take a contribute and say, no, this is a person where treatment can be tried. They say we can check this, removing the treatment after 4 weeks, after 8 weeks.
No, but then
So
that
lordship
should not be honoring his wishes.
No, because see, the point is,
No,
as
but
the lordship, there's
the
lordship.
motion said that you have a complete absolute right to, decide the destiny of your life at least. When it should begin, when it should end.
Yeah, no, but the point is, I'll put it this way, bro. There are two different things.
6 weeks. Ethics committee, etc. What happens in the intervening period? Is given the treatment or not?
He's given the treatment. He's given the treatment. To answer my lord, just Joseph's question. Suppose a person at 30 says, in the event of eventuality of my being afflicted with the cancer, I should not be treated. The suggestion which has been made is, if beyond a point, you can't simply say, don't treat me. If it's a completely curable thing. Suppose tomorrow you say, I've got a particular problem. It may not be cancer. It could be something which can be cured, but which may lead to further problems.
But
There, what I'm saying is,
so the person consciously can refuse any form of
no,
treatment.
because what happens is, in the lordship's question, what is contingent is, the person must have terminal illness.
But it is not mentioned.
It's not mentioned, but your lordship, that's why your lordship has to make it very clear, that in the event of my acquiring terminal
The
illness,
value of life also should not be,
devalued.
you can't be doing it because particularly in the rural areas, if you're going to, make it obviously contagious. That once the idea, takes hold.
But what was haunting the bench also was the possibility of misuse. How to curb that? That's the most important. Because today, my lord, today suppose it's a lawyer. Say a lawyer is there. As the Bible says, the young may die, the old may die, but the wisest know not how soon. So that is the statement in the point is, if there is a lawyer or a chartered a professional, what I'm saying is mentally alert person who can take a conscious decision. God forbid is affected with some kind of a rare disease which no known cure is there. And it's going to involve massive amounts of invasive treatment. Then the person says that don't do it. Like, just to example, in our own cases, grandmother is 94, 95. She tells the relatives that, look, please don't put me into a ventilator and drill a hole in my brain and all that. When they know they're ill, they say, if something happens, just let me go peacefully. I've lead a contented life. All my children are settled. This also is a common thing which we see.
That happens
Without advance record.
without it. Either when you go to the doctor, like you talked about the grandmother, the doctor will tell you, see, basically it's going to be palliative now.
Yes.
You've got a palliative
You
division.
take her home and let her be.
Be at home. So they abide by it and they take that's anything.
They take a call here.
What is the need for all this, this will apply essentially for a very select few people belonging to a particular section of society, which we may, at least I may, describe as belonging to the economic strata, which can go into such, it will be in specific terms, instruction will be absolutely clear, ambiguous, medical treatment to be given.
Bro, I think eventually it becomes like a will.
If you follow the life of,
Eventually becomes a routine. Sorry.
follow the life of Stephen Hawking,
Yo,
at the very early age there was a prediction.
he defied all odds.
Defied
And
all
Ishwar was telling me some cases where a person has recovered after 21 years.
Absolutely.
Like Michael Schumacher, the race driver, he's still in a coma. We don't know what will happen. Some stem cell research will revive him. We don't know.
Yeah.
He's still alive.
The real challenge is not how to define terminal illness.
Exactly.
He's got a very interesting.
Profoundly contextual. A person who is having some certain socio-economic impairment, terminal illness will descend on him much earlier than a person who is well equipped to have advanced treatment. That's number one. Number two, terminal illnesses which have been certified as terminal illness, namely PVS, persistent vegetative state. There are recorded information where the patient has survived for as long as 20 years. And after 20 years, they regain consciousness and they became. So different jurisdictions have tried to define it differently. For example, in Oregon Capital Deputy Act yesterday, that if the doctor certifies that the patient is terminally ill, and with all reasonable probability, he will not survive for more than 3 months. Then that's one paradigm. Now, in other states like Montana, Miami, their law says the period should be 6 months. While the law of assisted dying in Australia says it should be 6 months for all illnesses, but it should be 12 months for neurodegenerative disorders because they progress slowly. So the real challenge is, once I as a doctor certified, along with two of my colleagues, that we have examined this individual, and we find that he is terminally ill, and his chances of survival are not there beyond 3 months or 6 months. That carries no meaning. So terminal illness is one of the gray areas in this entire debate on euthanasia. Now, second gray area is the definition of death. When a person dies, the earlier definition of death was that it was a cardiorespiratory failure. Irreversible and permanent cessation of heart and lungs was sufficient to declare a man dead.
Brain death is nothing.
Now, in 1968, the Harvard Medical School debated the whole issue, and they came out with a brain death criteria, which means irreversible and permanent cessation of brain. But that was not taken to be final, because in case of cerebral failure, cerebral loss of cerebral function, that is different from brain death. The metabolic activities are intact, even if a person is brain dead.
Like you have the near-death experience theory.
So then when we drafted the Indian law, when we were drafting the Indian law on transplantation, this question came before us. Then we use the expression brain stem. Because brain stem, that is the lower part, that is the pons and the middle of the gata, they die after the brain. And even after brain death, the reflexes remain intact, the excretion remains intact, the digestion remains intact, the perspiration remains intact, the body's temperature remains intact. So the person is not dead. So because death is not an event, death is a process. One starts dying and then continues dying. And with advancing biotechnology, people are able to reproduce 48 hours after death. Because sperms are the longest survived cells of the body. So they continue to live for 48 hours. So there are various challenges, and people have struggled with these challenges, and different jurisdictions have come out with.
So supposing you say, Lata, it gets to you, that supposing in this provision, this 198.2.1, it says it should clearly indicate the decision-making circumstances in which withholding or withdrawal of medical treatment can be resorted to. If we simply replace it by saying that should indicate that the withdrawal of treatment should be made if it reaches the terminal stage.
As certified by the doctor.
As certified by the doctor.
Or as known to medical science at that point.
That's right.
The Lordship put it because now today, except one or two cancers, most are curable.
That's it.
Earlier it was completely not there.
That's it, exactly, with the one. So if you say that terminals, yes, then again what the doctor said, what really is terminal illness, again that will come into limelight.
Yes.
The second thing is what Bhushan, we are just taking from what Bhushan said, irrespective of whether it is terminal or not, do you have an absolute right to say, even if it is not reached terminal, if the treatment is very costly, for example, okay, if the treatment, despite the treatment, it is accompanied with, insufferable pain, even before it reaches terminal, because it may be, a bordering terminal, it is not yet reached terminal, it is surely going to go into the terminal stage for all you know, objectively. I say, please withdraw it. What will happen? So what do you mean by circumstances in which it will be withdrawn? How do you define, reconcile the right to life, that need to protect life, and also factoring in changes in the medical speed, which is so rapid, that we do not know where we are going to reach.
No, I would suggest, subject to what my colleague Prashant also said, Mr. Bhushan says, I think it will be risky or dangerous to say that even if a person is capable of being cured, he can say, I don't want to be cured. That, in my humble submission, could lead to problems. At the moment, we can confine, because today what the problem is, because this is a practical, because it's not a theoretical exercise we are doing. Today, what happens is, nobody is willing to take the decision. People say that, look, I want to, till the last money, I want to spend money. But we all know that beyond a point, the ventilator, of course, like he says, a person may recover after the. I know a case of distant relative. Man was in coma. One man was in corona on the ventilator. And they supposed to sign the form the previous evening. The wife and daughter said, we'll sign it the next morning. At 2 o'clock in the night, his fingers started twitching. Man is walking today.
Absolutely.
So these are all the, what you call unfathomable things of what may happen to individuals. We are dealing with a broad case where typically a person has gone into a coma. He's not likely to recover. Say he's brain dead. As doctor put it, he's brain dead. His body can be kept indefinitely 3 months, 6 months. Who's going to pay for that? He can't be taken home.
In the United States, there is a huge controversy which surrounds around the insurance companies because it's all insured there.
Yes.
So, the people, it was public funds being spent ultimately through the insurance company on cases which should be written off. Whereas if you come to England, you have the public health system.
Yes.
So there they have a different kind of problem. In India, we got a mixed kind of lot, which is perhaps better because we have both private hospitals and if they coexist together. In fact, that's how the whole theory of medical tourism comes. Which is now, which is a big thing, which is happening. People are coming, it's much cheaper.
Yes.
You get best treatment, they go back, and much earlier the treatment is done. If you go to Canada, it's got the public health system. You have to wait for months together.
Yes.
They even fix your tooth.
Yes, and costs. It's easier to come. In fact, my this the Supreme Court has given a qualification law that this can be done only when the person is terminally ill.
Where is that?
198.4.2.
198.4.2.
4.1 also relevant because it says becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and cure.
Yes, that's right. That's another caveat.
I have understood. 98.2 is a format. Is a format.
Yes. Like what a will is, what it must contain, you must sign
It's
it.
a format,
Yes.
which everybody has to disclose. 98.3 is how to be recorded.
Yes.
Form is to be filled in.
Yes.
Trouble, according to you, must be falling somewhere 90.3 because you are going through all stages one after the other. Magistrate, this, that is creating a lot of problems in getting a proper execution.
Yes.
So here, what according to you, 198.3 needs to be amended. So that
Yes.
can be made more workable
Yes.
and meaningful. With the right of safety and security of individual, protecting his rights in 21 can be.
Yes, but not only, as the Lordship put it, this main core safeguard is that when the advance directive was recorded, the man was fully conscious. He did it on his own volition, not through pressure of relatives and so on and so forth. How to do that? That's the question. So either he can record it before the doctor, or that he has given some 9 different methods. One simple method which can, and again, we should have a method which can be easily applicable in most parts of India. Otherwise, we can have sophisticated system which may become, like this guideline became unworkable. So I
Will
would
the declaration be disease specific or condition specific? Supposing what's contained going back to 198.1, 2.1, clearly indicated in the circumstances in which withholding. You've got a whole list of diseases.
That's in 198.4, at page 130.
Supposing he says one disease, and he is afflicted unfortunately by another disease which he never thought of.
Can you put omnibus terminally ill?
So it again will depend upon his imagination.
Yes. No, the Lordship will see 131, brother.
Huh?
Page 131 in the SEC. The Lordship has got SEC volume.
We got 198.8.
198.4.1. As Mr. Ravi pointed out, 198.4.1 should be read first.
Yes, terminally ill.
Yes, in the event the executor becomes terminally ill.
Ah.
And as doctor pointed out, some countries say.
That's not the point. The point that I'm making is, if you go and really on it should clearly indicate the decision relating to the circumstances in which withholding of.
Yeah, I agree with the Lordship point. Whether it should be cancer or it should be what we call a brain injury.
Or is it the condition?
Condition. Yes.
It's not, if he says, supposing he says this, a particular disease, I'm say cerebral stroke. It's pretty bad, it can progress and many of those cases you can come back. Most of those cases, in fact, you can come
The
back.
Lordship will take something like say Alzheimer's.
Alzheimer's.
There's no hope of the gentleman ever getting, he's alive because he's not. Through 2-3 years also a person can be in Alzheimer's, he may not even recognize his wife.
So what you're saying is this condition
should be 198.4.1 and.
That is only following the directive.
Yes, no, the advanced directive can operate because the Supreme Court has said this direction can be given effect to only when the person is terminally ill. That's what the
That's
Supreme
right. I'll
Court
give you
said.
an example.
Ah.
Supposing you, in the declaration, it says, if I suffer from any form of cancer and it reaches a particular stage, withdraw it. Supposing the man gets afflicted, say, with renal failure. He needs a kidney transplant or dialysis, and then it becomes painful, and then it is not there in this declaration.
The directive can be specific or general.
That's what you're
Yes,
saying.
it can be specific or general. However, it will be acted upon depending upon the board's advice or
That's right.
decision.
Therefore, what you're
Yes.
saying is the starting point and the end is also that the terms, circumstances indicating the disease or the condition with reference to it. I will give you an example. Supposing he refers only to any kind of cancer. He doesn't,
But he has renal failure. Yeah.
and he gets into renal failure, or he gets into some other condition.
Or let's say he gets into a stroke and he's complete in a coma. He will not have cancer, he will not have renal failure. Otherwise, the doctor says he's fully accept the
Or
brain
he
as a
suffers an accident. If forget about a disease.
accident.
Supposing he suffers an accident.
There is no directive. In such a situation, there cannot be.
Yeah, and
That cannot-
he's unconscious, indefinitely unconscious.
What happens in the case of an accident that is not covered? It is not a disease.
Lord,
No, can I just read 198.4.1?
Yeah.
Then we will come back, because that may serve some direction.
Yes.
1 and 2. No, if your lordship is reading the SCC volume, it's at page 131.
Yeah, you have produced a CC so that we are reading this
Okay.
from the
Yes,
paper book.
when and by whom it can be given effect to. In the event the executor becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and cure of the ailment, the treating physician, when made aware of the advance directive, shall ascertain the genuineness and authenticity thereof from the jurisdiction of judicial magistrate first class before acting upon the same. The instructions in the document will be given due weight by the doctors. However, it should be given effect to after being fully satisfied. Only after being fully satisfied that the executor is terminally ill and undergoing prolonged treatment or is surviving on life support and that the illness of the executor is incurable or there is no hope of him or her being cured. These are all the riders added by the board, which I think is a sufficient safeguard.
Just before that, let me clarify. Directive, number one, it can be general or specific.
Exactly.
In a particular situation, I may give a directive for a particular disease, where under it may be a very painful treatment I have to undergo. Such a situation, I can say, yes, my directive is specific for this particular illness. In such a situation, I do not want to continue the treatment. That can be specific. He can also give a general directive by saying that in any circumstances, if for this one I'm going for a terminal illness, then it can be done. That is a general this one.
Right.
Unless it is a general, if I give a directive for a particular one, it has to be acted upon only for that.
Exactly.
You can't take it for everything.
That's exactly what we were
Yes,
trying to tell
yes.
you.
It should be like that. That's the only possible
It can only
interpretation.
be, that's the only
Yes.
way it can be done.
Yes.
there are diseases, as your lordship pointed out, like cancer, like renal failure, like cerebral hemorrhage, like myocardial infarction, like fatal accident leading to cardiac preacher, then neurodegenerative diseases. Problem in the medical sciences is that the prognosis is different in different individuals. I have seen the most malignant neoplasm in this earth today is meningosarcoma
Yes.
of the brain
Yes.
and neuroblastoma of the brain, where the course of life is just say 3.4 years. And we have developed advanced techniques where by means of radiotherapy, we can focus the beam at the cellular level. It goes and destroys that only cancerous cells. And people have been surviving for years. So that is why the challenge lies in defining terminal illness. And that is why I was submitting to your lordship as to how terminal illness has been defined differently by different jurisdictions. Because it's a gray area, it's an ongoing area. So what your lordship is saying, that can be illustrating, but that cannot be a law in absolute terms.
Yeah, I can tell you one of my relatives came down with diagnosed with glioma, the condition of the brain. lesion in the brain. And at one stage of his treatment, the treating doctor said he's got 6 months. Okay, now he is alive for the last 14 or 15 years.
That's why I have submitted my lord. One of my patients.
So what they tell you,
So
then, but they say that this is according to our understanding.
that's why I'm submitting.
Doctors are not, gods that, they can really exactly, rather they are perhaps comparable a little bit more to, not exactly like the weatherman. Say that if the snow, perhaps you will have the sun.
No,
If I may
Not
say so-
exactly, I told you.
I said-
Doctors go by a science.
So this is all.
There's another thing which I wanted to point you when I saw it. The whole thing is revolving around only allopathy. The entire thing excludes the other forms of medicine. Take, for example, homeopathy.
Yes.
I'm only pointing it out, whatever it is worth. Ayurveda. We don't know. When you say that terminally ill, normally, objectively, we go by it because that is the predominant science. If you are not willing to completely discredit homeopathy, there can be situations where, it might prove.
No, bro, just to answer, bro, Jana, answer this.
For a doctor, any qualified doctor, having vast experience, it is very difficult to say that this patient is terminally ill as much as he will not survive for more than 3 weeks. If he says that as a doctor with 40 or 60, I say it's unethical on his part.
Absolutely.
No doctor.
They can say probable. They can say probable.
Because
That's exactly what I say.
But there's also one more
we
thing.
treat the individual, not the disease alone. Every individual responds differently to the same treatment to the same disease. So that is why I have chosen to associate myself with the
That's
celebration. That I know certain things which I have learned from my experience and from my insight. And the law evolved from such insight.
That's right.
No, the
Now,
one
for
more.
example, your lordship raised a very pertinent question. That somebody meets an accident. Now, accident is not a terminal illness. He may land into terminal illness.
Exactly.
He develops brain hematoma, he develops concussions. Suppose he does not, the nature of accident is not in the nature of grave injury. Now, there was a case 2009, in my compilation, I have quoted 32 pronouncement decisions of different courts. Now, one case from the Australian High Court, there was one guy, Christian Monitor, he was a sports person. And he met a traffic accident. He went into quadriplegia. That means all the four
All limbs,
gone.
all limbs are gone, yes.
He was hardly 40 years old. So for the rest of the life, he was chairborne. Now, he said that I don't want to continue in this condition. I have led an active life. Now, I am chairborne, my wife, my children, they are being put a lot of harassment and agony. So my life is miserable, I want to die. So all these questions came before the judges there. That how to say yes or no? Because this man is not technically. Then finally, the Australian High Court ruled that it is entirely the choice and discretion of the person concerned, whether he should exist in this state of life or not. Okay, he's communicative, he's cognizant, he's fully aware, conscious, and he's doing all in life except moving out of the chair. But he doesn't want to live. So assisted death was allowed, and all he wanted is that I don't want to eat. So I want to die by starvation. No active intervention by any outsider. I will die myself. That is one reported judgment which I have quoted in my
In
comparison.
fact, Jain religion gives you an example of,
Yes.
that you can do that. Many saints have done that. Yes.
In the cases from the Switzerland High Court Supreme Court, there
A
were
larger issue, that's a larger issue, your religious, spiritual underpinnings will actually come to the fore. Those are areas where, we are dealing with it on the plane of law.
so
We are only concerned with that.
No, but that cannot be applied in India. That I don't think this one. It runs against our principles. We can't accept it.
We are here. We are only here actually to consider improving the guidelines, because see, say, the point,
Improving para 194.
So that was his-
see, basically, we should realize how the limitations of the court are also.
Yes.
This is till the law is made by the legislature. Even this has been clarified. The legislature is definitely much more endowed with the multiple talents, skills, sources of knowledge which are required, which you know.
But major say was
Our knowledge, we are neither experts in medicine. We have a smattering of knowledge perhaps in all the fields which we claim, which is mostly actually furnished by the bar.
major suggestion.
We have to be very careful when you treat it.
I appreciate Lordship's concern that we did not go too deep into this.
And again, understand one more thing.
No, we only need to
That was
clarify.
decided on
It is
March
possible, that's
9,
all.
was
The job
taking.
is done.
That's why they was it for about 5 years. So even the legislature, they could not come up with a.
So what happened was it was posted for clarification. That's why they were waiting. Another problem. But to answer just Rastogi's question, please come to my compilation paragraph 361.
I'm going to give a turn there, while not. Drawings will be.
Go to volume 2 of application for clarification.
Confining to the difficulties which are being faced by
That is all that we are
implementing it.
I'm just giving a practical difficulty.
Yes.
After this judgment, people went to the judicial magistrate first class to record it. I'm showing the affidavit, advance directive which we had drafted and given. If your lordship meets with the approval, we can say this is the approved format. They can till the legislature gives a format.
So just let us see what are those things which you want to superimpose.
Yes, page 361 of volume 2. But there are two parts to it. What is, I divided into different stages. One is recording of advance directive, and this is Rastogi pointed out, what it should contain, how it should be recorded. In simple terms, what it should contain, how it should be recorded. That's the first one. Then the last stage is how it should be given effect to. So we can divide it into 3 stages. Contents of the advance directive, method of recording advance directive, and implementation of advance directive.
These are the three.
3 broad parameters subject to what is also.
So what are your suggestions?
Yes, now my suggestion is, as far as the advance directive.
You put it down in writing.
Yes, look, we drafted the advance directive in page 361.
So it's the same.
So this is the implementation stage. This is the post implementation. The post, please see page 361.
Volume.
Actual advance directive given by lady, which was refused by the magistrate at Mumbai.
Yeah.
What's this got advance directive of Mrs. So-and-so Miller? I want, yeah.
Yes, we got it.
Yeah. Residing at so-and-so, Shivaji Park, Mumbai 28. I am an adult of 74 years. I am an adult 74 years of age, of sound mind, and making this declaration of my own free will, that is voluntary and after careful consideration. I have received all information relevant to making this declaration and fully understand it as well as the consequence of declaration. If the time comes, what should we say? If she's 74 today, she is conscious. If the time comes that I can no longer take part in decision making regarding my medical treatment, this declaration will comprise the final expression of my wishes. It is requested that all concerned should take these wishes into account before making any medical decision regarding my life. If at any time I, 1, reach the stage of terminal illness and go into a coma with no reasonable expectation of regaining consciousness, or 2, I have a disease state from which I have no reasonable expectation of recovering with a quality of life that I would deem acceptable.
What is the meaning of that?
Disease has no reason, that is, I will never recover to a normal life, like a vegetative state.
Let's look at the way it is recovering with a quality of life which I would deem acceptable. What is the meaning of that? Who will find it out?
That can be clarified.
Clarified by whom and what stage?
How do you clarify?
No. Is one okay? Is one okay? One practical. Why is one okay?
Reach the stage of terminal illness.
And go into a coma with no reasonable expectation of regaining consciousness.
That's right.
So it's not just terminal illness leading into a comatose state
So you take a case of a terminal illness
without coma.
without coma, you'd be.
That the AIM form applies. That you don't get
What you're saying is if you reach a terminal illness state and the pain that you would have to undergo from the stage of entry into the terminal illness and the coma. The whole idea is to avoid that. You have to say that no, I will have to come into coma.
No, I'll tell you what happened in this case. This is a patient, what she says is, if I'm terminally ill and I go into a coma, then my relatives need not have the agony of taking a decision. It's my wish that if I'm terminally ill, because not advanced directive need not be a standard format.
Does a comma always precede a full stop?
Coma.
Yeah, what we meant was, will a full stop always follow a comma? You see what I meant was?
I know. The end, yeah. Comma is the intermediate stage, comma, grammatically.
What you're saying is, the doctor can tell us, if there is a comma, does it inevitably mean that the full stop is near at hand?
Probably it is a near.
No, my lord.
No, that's what we're trying to tell you.
Yeah.
No, my lord. People have been in coma for years together.
Years together,
My own
does it
previous-
necessarily mean that it's going to be a full stop?
So that is why I submitted the people's step.
Oh, very nebulous.
The basic dilemma is how to define terminal illness. And that is why the.
Dangerous, if you say.
That's why
going to
medical
coma,
Dangerous.
take it off.
It is
You may
dangerous.
come out of the coma.
Yes. They may come coma.
But no, the point is this. You will have a situation where 100 such cases, only one person has come out of the coma.
We don't.
That's what I'm saying.
At least I don't know.
I'm just saying. So, but the point is this. If you say I've got a right to die with dignity, it is no answer to tell me that, look, in your case, 3 people have come out of this illness. I'll say I'm not interested in those 3 people. I have enough of agony and she's 74 years old. Now, suppose this happens after 90, 95. The person may say that, look, if I go into a situation of terminal illness with no possibility of recovery or recovery with tremendous amount of agony, please don't give me life support system. This is basically on life support systems rather than giving medicines and treatments. 99% is on life support systems. So, my lord, we just give a sample to answer Mr. Rastogi's question. Is there any format? How do you record it? So, one is this kind of an affidavit or a declaration.
Yeah.
Yes. But
His right to end life has to be de-linked with the terminal illness. Otherwise, that advanced directive will become meaningless. Because how one will know that this particular person is terminally ill? Even the doctors will be hesitant to certify that he will die within 3 months or 6 months. And if they do it, that is a premature and wrong decision. That is contrary to Hippocratic oath. So the doctors will find it very difficult to certify. Doctor will just shut. So it will not be implemented. So the basic global paradigm is that a person has got to right to die. Once he find a right, the life has become very, very burdensome, cumbersome, regardless of terminal illness. So that is the first thing which has to be modified. In their lordship judgment, they have written that advanced directive will be.
Doctor, we will conclude hearing him. Otherwise, what will happen is it will hear you.
Okay.
That is better.
Fine.
yes. But now, I'm at the first stage is the contents of the advanced directive. Now, this is the contents. These are the possible contents. Now, your lordship has to decide how this is going to be recorded. It's just a sample. This is not the end all. Lordship can tweak it, modify it, because like para 198.4.
Short and brief. More you elaborate, more the confusion.
I agree with you.
More the problem.
Yes. Vegetative state, this,
That. If I'm not just making
yes.
it should be very brief. His wishes must be disclosed in the declaration form. Leave the rest for the medical board to examine as to what conditions are required, what conditions are to make his safety more.
I think so too. But as the lordship pointed out, the more you put, I deem acceptable, vegetative state, ifs and buts, then it becomes in. But this Ames form is being followed from time to time. The lordship sees that.
This is page
Page 11.
11.
I thought that could be the basic contents of advanced directive can be what Ames is following. and that can be recorded. So basically, point is terminal illness. Remember, there should be a balance between that man's wishes and also a potential misuse. As long as the man is conscious and says, I don't want it, we will respect that. And as Roshi rightly put it, people say, look, there is no point, just take him home, let him be happy. That can, please see page 11. And that's why we have given our prayers multiple options. So if your Lordship sees that today, if 194 can be modified to say that an advance directive is having multiple paragraphs of 3-4 pages, Lordship can just have a 1-2 paragraph advance directive saying that the patient, I'll put it this way, advance directive can be given a person for withholding life support in the event of terminal illness where the chances of his recovery are deemed to be remote by a panel of doctors. Will that be all right?
Yeah.
That's so. So please see aims. Patient's wishes for withholding life support. I with so-and-so admitted aims have a critical terminal illness where disease modifying options are no more applicable. Aims, page 11 of this parable.
Oh, yes, we have.
That may give a good working model.
Page 11, yes.
Page 11. Yeah, I spoke to the doctor last evening. They said they take this form. Patient's wishes for withholding life support. I with UIHD so admitted at AIMS New Delhi have a critical terminal illness where disease modifying options are no more applicable. Lordship is a good expression. Disease modifying options are no more applicable. I understand my general health is poor. I also understand the futility of life supportive measures such as endotracheal intubation, cardiopulmonary resuscitation, which will cause suffering without any reasonable benefit. My goal of care will be symptom relief, comfort measures, and quality of life. I hereby request you to allow natural death in the event of cardiopulmonary arrest, no external chest compressions, no intubations, no chemical or electrical cardioversion. I understand that signing this document would not deprive me of required medical and nursing care, pain and system relief modalities, and nursing care as appropriate, with the highest priority to maintain dignity of life. I say I'm making the declaration for the free will and there is no coercion.
This actually is very simply done.
Being followed.
And I think this, and particularly the patient's goal, my goal of care would be symptom relief, comfort measure, and quality of life. Like the example of the grandmother that you gave, I've led a full life. My children, grandchildren are settled. I don't look forward for anything more from life. And if I am to come to a state of terminal illness, I want to die in peace. So dying in peace should be a wish which...
Oh, we'll say die with dignity.
Dying with dignity, that's right. In fact, Article 21 also, when we talk about, this query came from the court. Article 21 also talks about life with dignity. It's not just, animal life, which is what the interpreters have said.
Can you, Lordship, then no Lordship, go back to 194. The advance directive, if I may suggest for Lordship's consideration, advance directive can be made by a person indicating that he wishes withdrawal of life support, to use AIMS language, where he has had a critical / terminal illness where disease modifying options are no more applicable.
Yeah.
It's very broadly worded. Critical terminal illness where disease modifying options are no more applicable. So your Lordship takes care of the medical science. So at that stage, are no more applicable. So this will be the examined by the medical board. Is there any options are available? That goes to a review board, which I'm coming to later when I come to implement it. So one question is, this can be a format of a declaration where it can be simple that advance directive is the right of a person to declare that if he reaches a stage of critical or terminal illness where disease modifying options are no more applicable.
Which part of this declaration are you saying it should be part of the
advance directive?
No, so this is in respect of somebody who is actually going to the hospital.
No, he's admitted as patient. He's got a number. Yeah.
So this may not be apposite when you are making it in advance.
Yes.
I'm making it as I am at 35 years.
No.
40 years. I have nothing. I have not gone to any hospital. So which part of this declaration would fit in with this advance declaration?
Yeah, I would say.
Which part? You just tell us.
Yes, I'm saying the first paragraph.
Which one?
I'm first paragraph.
Yeah.
that, can I suggest this way, Imran? I'm talking advanced directive, say a person who's 50 years old or a 60-year-old person who wants to make a will.
Yeah, he's perfectly healthy.
He's perfectly healthy.
Yeah.
He makes a will and makes an advanced directive. So what could he do? What's my suggestion?
Correct. What should it convey?
I would suggest that he will say, I am making this advanced directive which will enable the doctors or the caregivers to withdraw life support in the event of my reaching a critical / terminal illness where there is no hope of recovery or where there is no hope, where disease modifying options are no more applicable. And yeah, if we can recover, remove that my general health is poor can be deleted.
Yeah.
This is patient's wishes. Patient's wishes.
Who's already come to hospital, who's already got in the last
Somebody who's gone.
What just Joseph is asking is, suppose a person is 60, 65. Most people will make a will after they're 60, 65. They want to make a will now. They got assets, they want to settle the properties and so on and so forth.
Especially this kind of a thing, you know, we will have to ensure that this is not made under threat or coercion, etc.
That's the second part. How to record, just so speak,
And it is also there.
Yes, always, everything. Like a will also, but I can make a will. That's why you got testamentary jurisdiction. They say will is made under coercion. You're not under medical thing. He's given the property to that son who was looking after him only. He influenced him. So all those problems we've got, at least in the Madras High Court, we've got original testamentary jurisdiction. So
So he is giving, see, this directive, advanced directive. At a stage when he was healthy.
Yes.
which one?
No.
Exactly. No,
Therefore, under what circumstances he's making it?
No, it could not
That's
be.
the point we look into.
It could also be, suppose a person gets afflicted with cancer. He hopes for the best, but he now says, all right, this is a possibility, this is an eventuality I'm going to face. Or suppose his case has got renal failure and it is galloping. He knows that this is an eventuality. There's a miracle that I may survive. So he may make it when he's healthy. He may make it at the very last stage. He may make it in between. The most important thing is he should be fully conscious of what he's doing.
These contingencies were actually envisaged under 198 for 1 and 2.
Yes.
Politics is there.
No, the question what Dr. Kishore pointed out is the High Court, the Supreme Court says that you will implement this when there is no hope of any cure. That I'll come to the implementation part. Now, Murad, I'm just going to the stage where what should an advance directive contain till the legislature declares the format. Because today doctors have got a practical problem. Nobody is able to take a decision. They don't want to take a decision. They're afraid. Suppose something happens. So now if there is a Article 142 direction or Supreme Court direction, this is if an advance directive is in this format, it's a valid directive.
So, Mr. Datar, we have to tweak it a bit because this is applicable for a patient who is already admitted. So we have to say that in the event of my being admitted with these conditions which are mentioned
Yes,
there.
that's a good idea.
You know, we have to start off by saying in the event, because somebody 40-year-old, 50-year-old, somebody has to, he's not admitted. Yeah, he's playing his tennis and his whatever he's doing.
Or an accident.
Or an accident kind of a thing. So
there's also a distinction between a critical illness and a terminal illness. Yes. Here you have actually brought in both. See, how would you define critical illness? There are so many critical illnesses. No, we are telling you.
So can we'll restrict to terminal.
Ah,
We'll restrict to terminal. My God, let's not get into critical. Critical can be what is critical, what is
we
not
don't know what is
critical.
critical.
Subjective.
There are so many people who come out of so-called critical conditions.
There's a big theory of mind over sheer willpower you can.
Word critical has been consciously added here.
what is critical for a
Because
normal man? What is critical for a normal man? Is not critical for Michael Schumacher.
That means
We are saying what is critical for an ordinary person of normal wealth. What is critical for a
this word
Is it critical added for a
critical has been consciously added in these judges.
no. What we are saying is the element. What is critical for another person is not critical for Michael Schumacher.
Yes.
We are talking about somebody of that capability.
So that criticality of illness is individual oriented. A person may find himself in a critical
That's
illness,
right.
other may not find in the critical.
That's right.
Yes, therefore,
These are the real.
yes, yes.
So just page 46, 47. Manipal Hospital has given.
unnecessary.
So these,
This company has more than 130 crores of.
they are a capital wide import. Critical
And
illness.
tell us one thing. We have a human donation or organ donation.
Correct.
Government has tried its level best to promote but no sane person is coming forward to.
No, I'm sorry, but there are a lot of people now giving eyes.
Yes, but very.
They got harvesting the.
Looking to the total
Oh,
population.
yes, it's only the metros. It's only the metros.
Correct. You're talking about literate class people, elite class people. Nobody can put somebody for himself. Oh, something is going wrong to me and I'm going to do it. Very difficult to say. Now we're talking about directives, advanced directives. Advanced directives can be at any point of time without age barrier. But you will find hardly people, hardly, not even 0.1%, who would be coming forward to give an advanced directive at the age of 45 or 55. So, as long as I am healthy. Mostly people, when coming to a hospital in a critical state of health, with the treatment, they know that what is going to happen with me. They may come forward, all right, now I don't want any kind of infusion to me. So this form which you have just read over to us is more workable. Keeping the riders over it, the medical board to examine, so that so nobody can misuse the kind of a declaration being sought from the patient, who might not be in a position, may not be in a position. So we want to know from you what kind of a safeguard which you can put while this form is being filled by a patient admitting to a hospital, so that nobody can misuse this proposition. So when advanced directives are concerned, like in 98.3, this magistrate and all theory, this is cumbersome. You can simplify so that any person who willingly want to have advanced directives can go through the mechanism by filling the form of 98.2, and 98.3 is an over barrier to put how the mechanism to work. Give us a simplification of 98.3.
Manoj, can I suggest?
And 98.4 follow with 98.1.
Manoj, can I suggest one thing, Manoj? Many of us have made wills, and we make the will in the presence of two witnesses. Now, one option is like an advance directive, also like what called living will. So it's also part and parcel of the will, because many of us say that, look, I will say that I don't want to sing. And we also say that after me, I don't want to elaborate religious ceremonies. So many things we put in the will. Now, just as in a will, the safeguard is why you have two witnesses, to show that the person, the testator, was in a full faculty, there was no coercion. So like that, if we can have a saying that I don't have a magistrate, just as if I make a will in the presence of two witnesses, why can't I make an advance directive in the face of two witnesses, which anyway is not going to be acted upon unless there is one board and second board. There are two boards which are going to reconfirm for taking off the treatment.
But here, see,
Yeah.
the one independent witness should be there, then of course.
Or doctor can be
the
there.
Magistrate also, and they will have to record their satisfaction.
But my request is, let's not get the magistrate into the picture. My humble suggestion is, if I can today make a will, where I can also say that, look, many people say that after my death, he's
Will
doing
is something,
Yes.
understand one thing,
Yes.
will of course is the property, etc. Now he has very life,
No, I'm saying like a will. What Justice Rastogi says, how do you record it? Do you go to a magistrate? Do you video record it? Do you go to you go to a notary public? I'm just giving example. Where do you go? So, pardon me? Yes. One option was to go to a notary public, or one option, I'm just suggesting, can I put it this way? Advance directive can be recorded in the presence of an independent witness, a non-relative, and a doctor. So those two can be there. It'll be simple.
Yeah, but this advance directive, as you call it,
Yeah.
in what area
Yeah.
will it actually have operation? You see, if I am healthy, okay, then I become sick, then I reach a particular stage, I can either make up my mind myself, I don't want the treatment. Nobody can compel me to get the treatment. Right. It applies perhaps only in that narrow area where he becomes so ill, that terminally ill, that he is not in a position to say, please stop the treatment, I don't want it. I think this directive will have use only in that area.
No, but can I
That's specific.
No, can I?
Otherwise, he's a man of free choice. He can always say, I don't want this treatment.
No, Lordship is right.
It's only when he goes into a vegetative state or a state of coma, as he calls it, then he can't take the call.
Can I put it?
Somebody else will have to take the call. Otherwise, the choice is always there. He can say, I don't want it.
No, I'll put
What
it
is the real utility of this advance?
until Lordship.
Lordship is that. Sir.
Yes. What your Lordship is saying is, if I am a person who becomes ill, if say mistakes becomes ill, then he goes to hospital, he takes a call.
He may even not go to the
Yes,
hospital.
he may
I
not go to
don't want
hospital.
to. There are so many people in our country dying that way.
Who don't want?
Who
No,
don't want? I know that the rural area particularly, they say, I don't want, it's okay, he's had lived in it. The doctor is saying, I don't want it. Fine. Nobody can compel it.
not put it
Not
this
a
way.
case of,
No,
306.
correct.
Where you're committing or abetting and all that. Nothing is there.
There are multiple,
Just said, I don't want it.
multiple
Can I say
circumstances here,
sometimes question.
sometimes.
Where advance directive will come? Sorry.
But just one, such as you pointed out, such circumstances in the rural areas may be due to various factors. Because of number one, maybe financial condition. He may say that I can't afford to go for this kind of treatment. So let me die because I have had a good life.
Have you thought of a legislation in this field? 5 years.
That's I have to. I'll come back by.
But we are giving a bill also.
And,
This draft
yes.
bill.
Is,
So
it
that was-
not, is it not essentially a legislative function?
It's a legislative function. It's a legislative
Then
function.
why
without
don't
a-
you, if the legislature has applied its mind and you are representing this
Correct.
government,
Yes.
why don't you,
No, what has been done, before end of these proceedings, definitely I'll come back to it. Because that was suggested at the time of the judgment also. They
Legislature
said,
will come when it comes.
But then what you're saying.
What the answer is, no, this will come with a case where a person doesn't become ill and go to hospital. There he can fill this AIMS form. There's no problem.
No problem.
A person, it could be happen that a person signs at the age of 60, 65. He suffers a stroke. He goes into a coma.
So that is the
Yeah,
area.
that is a normal area where
That's the only area.
yes, perhaps.
Right. Why do you say any other area? That is the only area. Otherwise, it is always a matter of choice. He can always.
That's why in some countries, there is a minimum age requirement is there. You just go through para 196.
No, I will.
196
Yes.
of the village,
Correct.
the British Columbia, etc. No, minimum age requirement. Why should a person at the age of 30 should believe that yes, I may become like this?
So 60 years.
And therefore, a minimum age requirement it is there in certain countries.
Washing may put 60 years. Only people above 60 years should make it.
This situation was also very much discussed in para 196.
So basically, the magistrate.
Even for writing this advance, sir.
Brushing itself is a difficult. I can look at your eyes.
compartmentalize these issues. The first one is the deponent or the proponent. That is his wish he is going to express, number one. First part, he can express when he is in a healthy state of affairs or healthy condition, he can do it. Or when he anticipates some kind of ailment which may end up in terminal illness. That is the second one. The second one is when it has to be executed. That depends upon the doctor's call, the medical board. That is the second step. The most important is what are the conditions will have to be fulfilled, what are the safeguards will have to be taken for the purpose of recording these kind of the directives. That will be most crucial aspect. When he expresses his desire or the issues a directions, what kind of safeguards will have to be like a dying declaration when we believe or when we accept it, what should be done in such a situation? Similarly here, when he gives a directive, what are the precautions will have to be taken because it has to be acted upon later. So therefore, I think in the present situation, we have to first focus on what are the directives will have to be procedurally protected.
First of all, we will have to go through the already laid out directions.
Correct.
Guidelines,
Correct.
and thereafter, whether any clarification is required or not.
Absolute.
But you are
Yeah, the main clarification is this multiple going to the judicial magistrate, multiple boards, that is the point. that we
Why
eliminate.
don't you concentrate on that?
Exactly. So that we are confident.
Otherwise, let us not tweak, what has been laid down as to the contents of this advance declaration. Because the content, there are two.
Can I do one thing?
Content will just tell you one thing.
Yes.
A person can say, they refer to the diseases which he dreads, and then say, then this happens and if I go into a sort of vegetative condition or a terminal illness, and then it should not be given, treatment need not be given, it shall not be given. Or he can say the choice of conditions which may be common to, where you are ending life, coming very close to life, which is going to be painful and where he will have no control because he slipped into a coma.
Can I just one?
Short of the period because if he is not in a coma, we are telling you again and again,
Yes.
the kind of people who are going to make use of this facility are persons who are capable of taking care of themselves. They'll say, I don't want it. It's the end of it.
They'll fill the
Why
aims
do you-
form.
Huh?
They'll fill the aims form.
Fill the end form. Why do you need this? For whom? For whom is it?
No, the point is, as your lordship rightly put it, this is to aid people who have lost their decision-making capacity.
Exactly.
So they have taken because
That is where
pointed out, as Chancellor Ravi Kumar's question, FY40. I'm told that Mr. President Obama and his wife also signed the directive when they're 44 years old.
That's right.
That's a different matter, but that doesn't matter. But
See, we don't have to,
Follow
we don't have to follow the West in all that we do.
can I do
There
one
are
thing?
ideas, modern ideas. There are ideas swirling around the whole of the world. What is good, we will take it.
But can I suggest one thing?
Okay.
I will take para 194, put it on the left-hand column, and right-hand column, I'll say which right needs to be modified. So I'll give your lordship a complete chart.
Well, let's do it.
This is what 194.
Let us do it right now. This has come up on 2-3 occasions.
Yes.
Let's close it. Otherwise, again, we can't be having
Yes.
a constitution debate again all over again.
Yes.
So then get down to it.
Yeah.
And basically, you should be into the, the checking mechanism. That is
Yeah.
where perhaps you have a problem.
Yes.
This first a medical board, then it goes to the collector. Collector constitutes a medical board consisting of the chief medical officer. He again, they also counter certify it.
But can I
That is
suggest?
the area I think you have a problem.
Yes, yes.
Tahsildar. That process perhaps it should be.
I'm going to suggest for my part, Lord, that simple, it can be declared before two witnesses, one independent witness, and it can be before a doctor.
That we as good or bad as a will.
Exactly. Keep it at that. Keep it at that. Because otherwise, there's no amount of safeguard is going to be there. How does the magistrate know, Lord? And first of all, magistrate has to come. Nobody has the time. Now,
It can also be part of a will also.
it can be part of
Part of a will
It
also.
can be part of a will also. But if the will has an advance directive, then one witness should be a doctor, is my humble suggestion.
So there is a problem with the will, I'll tell you. I make a will. Okay. I leave it somewhere. Okay. Now, none of my relatives know about the will. The will ordinarily takes effect only on the death.
But normally we hand it over to the executor. Normally we put it in a seal cover and give to the executor.
Therefore, we have to say that.
Yes.
Can you say simply if you say will,
No.
it is capable of being embraced in various circumstances. Supposing I make a will and I leave it, I put it in my almirah, nobody knows about it. How will they give effect to it?
Correct.
Segregate.
If you want to make it a will, if you want to make it effective, it should be known. Secondly, it should be known also to the close relatives. So it is better that it should not be in a will. Why we tell you?
Separate advance directive.
Segregate. Segregate.
The contents of a will, you will be alienating at least some of your. So it should be a separate document, not.
I fully agree. Let it be a separate advance directive. Exactly. And what it
should be known to the relatives so that it will be given effective. If you want it to be given effective, I am not particularly keen that personally. But then that if it is to be given effective, it should be known beforehand. It should be made with the full consciousness. That's all. And then give effect to it. I mean, if you want to die in peace, as you call it, so be it. Let us not make it very cumbersome.
Yes. Yeah. Absolutely.
Correct?
So, Lord, one thing, I can do it right now, or would your lordship?
Right now, let us close it. As is, what I give the
No, but that's it. It should be that.
it should be. Our brother is saying it. Perhaps by tomorrow we can
I'm
go
about
on
to
to
say
the
that.
other matters. So you will come better.
I'll just take 194 and tell your lordship. Now, I have 2 points so that I do my homework. One is, as far as advance directive is concerned, 194.1 says, I will go by the same format, what it should contain. This question which your lordship has got, just to take 2 minutes so that we don't don't.
198, not 194.
No,
198.
no, please start with 198, yes, yes.
98.
Yes. Now, my lord, just, the lordship just help me, I'll just then, so that tomorrow time can be much easier. Who can execute the advance directive and how? Lord, I don't think we should put any age limit. We leave it to the person unless your lordship wants to say it should be done by a person above 60 years. And your lordship may just think about it. Whether you want me to put an age limit or put 40 years or 50 years. Whatever your lordship says.
I don't think there should be age limit as long as you are a major. Because this can happen at any stage.
We only said that that was considered earlier. So Para 196, that was there.
One second, para 196.
Take a note of the fact that in some countries, this was one of the criteria.
Yes, Lordship, yes. Lord, who can execute? And I take a lordship suggestion, it will not be part of the will.
I don't know the medical side. If you see the branch of psychiatry, what they say is that the human brain grows up to perhaps the age of 10, 11, physically. But the personality development, you stabilize somewhere around the age of 25. Got something
Yes,
to do
yes,
with
yes.
criminality.
Yes.
It's an area which is emerging.
Yes.
When if juveniles 18, but beyond that, there is an age up to 25 when your character, the personality development continues, evolves, which is why you have a lot of crimes between the age 18 and 25, where you have to view it perhaps differently. It's a matter for the future. That's what they say.
No, I just take it that who can execute the advance directive? Any person of a major in his right mind.
Can we make it 25? I'm just making a suggestion.
Yes,
I don't know whether what my brothers will.
No, I was thinking better to make it above 50, bro. That's my suggestion.
50, actually in the Indian context,
Yes.
where the family also, an 18-year-old person saying that this is what,
He may not
his
pay-
parents, his uncles, his aunts, everybody is there, So perhaps a more mature age.
30 years.
50 might be a better
I
idea
was suggesting 50, my lord. Better than 50 or 60.
and not part of the will. I was not correct there in suggesting
For
that.
certain ailments, I don't think we have to wait till 50. For certain ailments, it may, somebody, no,
Accident can happen much earlier.
not even accident, some ailments, it might be diagnosed you are at the 30s or 40s, at least some 40 would be little better, I think.
But on my side, they are saying let there not be age limit. Let there not be an age limit. It's up to a person.
No,
What's the-
my respectful submission is that it will not be desirable and wise to fix any age limit
We'll leave it to them.
executing or making advance directive.
18 years is option.
Yes.
No age limit.
No, major. Has to be major.
He has to be,
Yes.
he should be a major. Above 18 at any age.
Since
There is
this,
no jurisdiction of the world this age limit has been given, except for minors. So that will not be.
Otherwise, the next problem will come that he was not adult that time. So there should be a separate inquiry.
So we don't.
Leave it. Like in juvenile, in our juvenile system going on.
Should not be-
After 30 years,
So there's no age limit.
after 30 years, we are asking for an inquiry to decide whether you are juvenile on that day or not.
All right.
So, Bharat, we'll say no age limit, point number one. Point number two, it is not part of the will.
Then,
It has to be separate from the will.
one more thing.
Sorry.
Then please read 198.1.1.
One,
198.1.1.
Yes, ma'am.
Already it is there. Advance directive can be executed only by an adult. So if we say that there is no age limit, that means it's as good as
It's taken care of.
modifying age.
It's taken care of.
198 or 1 is already
no,
there.
no, your lordship suggested above 60, so that's why I mentioned.
Mr.
So-
Mr. Tata,
Yes.
198.1 is clear,
Yes.
198.
Point two is clear. Yes,
Come to 198.3.
also clear.
Here, no, 198.3 where the recording of this is magistrate and all business goes on.
Yes.
This you suggest what modification according to required.
We just need a general presence of two witnesses.
Two witnesses, independent.
Two independent witnesses and one doctor.
For doctor who, doctor who,
I'm just suggesting.
no, which doctor, what standard?
So if the family doctor can say, or two independent witnesses can be there, because ultimately it's going to go before the board.
That's correct.
So that safeguard is always there. It's not that since I say so, I'm going to immediately allow to die. There's a primary board, there's a review board, there's a 6-step process in there.
Riders are there.
Yes, yes, those safeguard will, so I'll do one thing, but simply make it signed for two witnesses. It should be separate from a will. And in the will, I can indicate that I've also made an advance directive. And as Justice Joseph pointed out, it should be declared, known, that an advance directive has been made and it should be known to the person. How do we make it known is another question.
One is, digital is there, that is being recorded digitally.
Any data bank is there of advance directives?
In my compilation from page 1 to 6, I have answered all these questions. I made a table in my compilation from page 1 to 6. Seriatim I have answered. What is the problem with the judgment and how it should be addressed? Each and everything that is being discussed here, I have written.
But I'll do one thing, I'll sit with him and we'll finally debate tomorrow.
Page 1 to 6 of my compilation. I have made a table about the magistrate, about the high court, about the district judge and everything.
That's right.
It's a ready-made answer for all those naughty areas. What else?
See, Mr. There is one thing, 198.3.
Now,
198.3, it says how it should be recorded and preserved. It is already there.
so that,
What is the clarification which you want in that?
198.3 is the main problem area.
That is why
yes,
it is already there. How it should be recorded and preserved. It is already there, laid down. And what is the clarification? Because it's only a clarification petition. You are not rewriting this. So already the concept laid down how it should be recorded, how it should be preserved. So what is the difficulty in that? And why you are seeking a clarification? And if so, in what manner?
No, because what happened after the directives came, it was found very, very difficult to go to judicial magistrate first class.
That is why.
Yes.
So already 198.3 is there. Therefore, you will have to say what are the difficulties being experienced
Number one,
and in what manner the modifications are required.
and one more thing, even if 190 is recorded, it will not be.
Which person?
How it is to be preserved.
Reserved in the register to the district court.
How it should be recorded, first thing. How it should be preserved. It is already there.
I know that, but that's why
Therefore-
we say
therefore,
some of the most.
What were the difficulties experienced while following these directives? That should be there because already directives were there. So you will have to come up with the difficulties, practical difficulties experienced, actually experienced.
No, there is no actual experience there because we have gone to magistrate, they refused to record it. On page 15, PC page 15.
That one question, because it is a person actually has to be, a magistrate has to be deputed for that particular purpose by a sessions judge going by the list.
But it's not possible. Please see page 15 that Mrs. Mehta went, the magistrate was not available. He refused to come. He was held up with bail applications.
Legal service.
And what is the purpose of assigning before a magistrate? Ultimately, if the primary board and review board is going to decide whether to take away my medical care, what purpose is served by going to a first class magistrate?
What about an audio video recording?
Yes, it can be. That's one thing I suggest. It can be audio video recorded, it has to be preserved. Now the point is, where do you preserve it? Where do you preserve it? Is there some data bank? Say, is any hospital will have a wing or a court will have a wing? We don't know. Like for example, will you can register a will. Possibility of registering the will.
Why we are
You go to register.
questioning?
Sorry.
So long as this 198.3 is there, it's not a review. You are not going to review everything.
No,
And
this
therefore
is for
you will have-
modification. This is for modification.
that is why, so understand that and then come up with.
Yes. But that's why the bench also was thinking that this is unworkable because if it's not, the point is the whole this is ultimately what are we trying to do? We are trying to say that when a person is in a vegetative state and he's not able to decide, please allow him to spare the relatives the agony of taking a decision. It's not for the person who's anyway in this thing.
No, we are now dealing with advance.
No, I'm dealing in advanced directive. What
Advance directive is something that is being made at the stage when he was guilty.
Phenomenon.
Natarajan, this preserving is important, so
Yes,
that everybody gets to know,
Correct.
critical person,
Correct.
the family members. So can we not have a digitally recorded thing
That's right.
and then a portal
Yes,
which is applicable all throughout
Correct.
the country,
correct.
where it can be preserved. So anybody who gets admitted, now every person say
Correct.
Aadhaar card or whatever connection,
Correct.
we suppose that is there, that immediately
That's
when you
right.
get into the hospital, you have to give your identity
Correct.
number. So through the Aadhaar card, all right, there is an advance
Yes.
medical directive of the declaration of this person,
Correct.
something like that.
Like a large, if practice from a large country like India, where do you record it?
No, so therefore, should the government not come out with a portal where this has to be recorded?
So, come to 198.3, everything has been taken care of minus this magistrate business.
Yes.
Minus magistrate's business,
Yes.
digital format, where to be preserved, what is the agency to work, everything is there.
No.
minus magistrate business and the satisfaction.
No,
Everything goes in order.
handing out a municipal corporation, all that becomes unenforceable.
But the 193.1
Yes,
document is signed by the executive in the presence of two attesting witnesses,
all right.
preferably independent, no problem. Countersigned by the magistrate, we can substitute what magistrate, what can be the substitution. 3.2 goes minus this substitution of JMFC. Satisfaction is recorded and full understanding goes and everything goes in order. Nothing required. Come to 3.3. It has to be preserved in addition to keeping in the digital format. 0.3. Now, how it has been preserved, that is the mechanism the government has to find out.
Portal.
Whatever the mechanisms. 3.98, 3.3. Now 4. Only minus JMFC business. So you have to substitute in minus JMFC. What could be a substitution which make the system more workable, effective, and to the satisfaction of the executor?
Either before the registrar or before the notary public.
Registrar of whom?
It says, it has to be signed before the registry of the district court. So it's going to the district court, one is like a will be registered, a will before the registrar.
Yes.
Or we sign before notary public. But we are making it as easy as possible.
That's correct.
Because I'm only worried.
But keeping the safeguard also.
Correct, and I'm submitting that the safeguard is in the primary board and the review board. Here-
You may explore the, possibility of using the legal service authority that has a deep reach. And usually a judicial officer
No, where I'm coming
is
from.
the member secretary.
Where I'm coming from is to record it in a particular place, keeping this is a big problem. I'm saying if it's an advance directive signed before witnesses, let it be there. So what happens is when you go to the doctor, you can say, I've got an advance directive already there. Then they say, okay, since it's advance directive, then there is no need to get the consent of the.
The authenticity of that, like we.
Yes. That's the only problem. That's the only problem.
That is
We're
challenging.
only worried about that. Now, the point is, one is to make it either file it before the registrar or have some kind of data bank, but how do you do in a large country like India?
The
large
large country, we
Government of India is there, they can.
we can tell you one thing, this large country like India, when you said, this is going to affect a very minuscule percentage of the population. It is not something which is going to be made use of by the very large predominant majority of the Indians. This is going to affect a very small percentage.
At the beginning.
At the very beginning and.
No, it may pick up also.
Yeah. You don't know whether it's that's something which should engage the legislature.
Or can I say this one thing?
Yeah.
Many of us are registered with some hospital. We generally get registered with Apollo hospital or this hospital or that hospital. We got a number because when you go for a treatment, first thing they ask is, have you been registered? Because before you enter a hospital.
Correct.
So one option is to say that whichever hospital I'm under treatment, that hospital can simply keep that thing as a record. That's all. That's why I said above 60, because if I'm 30, how can the hospital keep the record for the next 40, 50 years? One advantage of keeping it after the age of 60 is it reduces the recording.
Might require some kind of permanent recording.
Yeah.
That possibly.
Yes.
The larger,
We have to work out at the same time, creating
the larger population is below 35.
a portal that may create
No, I'm
kind of
afraid
one more issue may arise for.
recording. There's no repository. No country there's a recording.
All these directives which no jurisdiction have to come across.
It can begin from this jurisdiction.
These advanced directives are not preserved by any governmental or executive authority. They remain with the patient and their family members. That is the legal paradigm prevailing, who have been practicing in India since 1997. And not a single case of abuse has been reported.
If it is later on discovered that advance directive was a counterfeit or a fake one, then who will take responsibility of that?
The whole thing is the approach. So we go there because there could be one
Because
possibility.
for will, the testamentary jurisdiction,
Yes.
the will has to be specifically proved before the court before being
Yes.
given effect.
If there is a contest.
No, otherwise also
Also,
court.
we have to prove it.
No. I'm saying suppose.
Without a contest also, you have
No,
to prove.
suppose the bill is there and the family agrees to that.
No,
contest,
it has to be proved. It has to be proved.
So
in
if I
an
want to get a probate or letter of administration.
No, even in any proceeding, it has to be proved.
Correct. If there is a litigation.
Madras
If
President.
there's a litigation.
Yes. This is, no, we have, Lordship knows about Madras, we've got this testamentary jurisdiction in the High Court. and separate-
Where a will before being given
Yes,
effect
yes,
has to be.
And if the will is contested, it becomes a TOS, becomes a transferred origin suit.
Otherwise, uncontested, they give the,
It's a OP, there's a petition in the for the letter administration.
it has to go through the judicial process.
But I'll keep in mind this concern, we just, tomorrow we'll.
situation-
know.
The situation,
Instead of the magistrate, because the magistrate, first of all, he has got so many functions.
Yes, impossible.
So a gazetted officer, but not, enumerate a few of them. So that widen the basis instead of magistrate. Because otherwise, to trouble the magistrate for this.
this twofold, in this situation, we should have sufficient safeguard. That's most important in the matter.
That's why the
Yeah,
court went
number
out
one.
to.
At the same time, there may be one more issue which may crop up for this one consideration would be some directions are it must be made known to that person, this officer and all those things. If my directive, if it is to be made known to somebody, that may offend my right of privacy also. That also has to be taken care. That's one of the aspects which may crop up for consideration. Definitely that will trouble. Suppose I am suffering from a particular ailment, which I do not want that to be made known to others. By implementing this direction as it is, my ailment will be made known to everyone.
No, I don't.
Yes, that problem will, no, tomorrow will come up with the same theory. That may be my wish. I do not want this, my ailment to be made known to everyone. So we have to protect that as well.
Today you are not.
Come out only.
So therefore we have to confine to the,
190.3.
yes,
How can we substitute in reference to the JMFC basis?
yes.
And
That's
safeguard
right.
the interest of the
Correct.
individual?
Yes.
The right to privacy has to be given its freedom.
Correct.
No, one more thing. As far as 198.4 is concerned.
Yes.
This double board thing is a little problematic.
No.
Twice you have to go to two boards.
No.
That you have no problem.
No, same one. So now the homework is to see what can be done to make 198.3 workable. Other point is 198.4, which was also deliberated in great detail with the health secretary, AIMS doctors and other people. Kindly, this is what we're suggesting. If the Lordship approves this, then we can work on this and give a suggestion.
Yes.
Now, this is where an advanced directive exists.
Yes.
Now, Lordship is to visualize a person who has come to hospital. There is an advance directive. He is terminally ill. Then what happens? I just read not step 1. May I read now?
Yes.
Treating team of a patient to confirm that the patient lacks decision-making capacity in relation to decisions about medical treatment. Step 2. So, Lord, this is called the first primary board. Lordship will call, we have called it step 1 as a primary board. Step 2, primary board. Primary board to confirm. Oh, sorry. Step 1 is the doctors treating him. That goes to a primary board. Primary board to confirm that initiating, escalating, or continuing life-sustaining treatment would not be beneficial to the patient. Primary board to consist of the treating team of the patient and a member of the hospital ethics committee.
Does hospitals, all hospitals?
No, large hospitals have, but they put wherever applicable. So Lordship may just put a comma here that wherever I'll add it wherever applicable, because it could happen in a smaller town. The hospital may not have an ethics committee.
Yeah.
Assessment of the primary board to be ratified by a review board.
What is the review board?
Yes, because before they decide to, because this court also has suggested a second, why we did this was, the Supreme Court said there should be a multi-tier check. So what is a multi-tier check? Instead of going to the collector, then the judicial magistrate confirming, then what the Supreme Court says is, the collector will form a separate board.
That's what you're saying.
Yes.
Is that feasible?
No, so we said, we put a simple review board. Just imagine a person goes to, let's say, AIMS or goes to Apollo Hospital or some hospital. His doctors say that, look,
Well, the amount of reviewing, there's a basic problem is, once you get around to, getting rid of the second review board or the chief medical officer board, we'll be rewriting that portion
yes,
of the judgment.
yes. If you were to make workable, in this form, it will not be workable. Our Lordship will kindly see. Step 3.
Becomes a review, but in modulate.
Modification. I'm not saying because the order 47 rule 1 applies.
The public interest litigation, basically, one suggestion which I have is, one way of doing it is because in the primary board, you can always include the chief medical officer. Because the chief medical officer is brought in the second review board So as to give some kind of an authenticity.
Sorry, there's a doctor here. What happens, I'm told that this decision may require quickness, so they just want one independent director and somebody from the ethics committee. The CMO may not always be available, that's another problem. Then
What you're trying to tell you is that if the CMO is made a party.
CMO or a person delegated by him,
Huh?
CMO or a doctor delegated.
Somebody from the government department. The whole idea is that.
No, it could be say, let's say in Madras, say it's a large private hospital.
That's right. But somebody must be either under the authority of the CMO.
Or the head of the hospital.
Either the CMO.
Or the hospital's director.
Correct. If he is part of this review board, then there need not be a further review board.
No, is your lordship thinking of only one primary board without a second review board?
That's what I have in mind. If that is done, because of, what is the whole idea? If this is meant to be effective, by the time you go in one review, second review, the man under is
I was just following the Supreme Court thing, having a two-tier check. That's why.
Yeah.
He may.
No, I'll put both ways. Lordship may take a call. Lordship may.
Just suggesting everything to what my.
I'll just see the further steps. If the Lordship approves it. I've come to step 3, my Lord. Lordship may just see step 2. Assessment of the primary board to be ratified by a review board. Review board to comprise doctors outside the treating team of the patient, but at the same hospital where the patient is being treated. So no need to get outside doctors, collector forming a board, etc. In smaller clinics or nursing homes, where there may not be enough doctors to constitute a review board, the assessment of the primary board should be ratified by an independent doctor from a government hospital. Step 4. Once the primary board and review board are in agreement that initiating, escalating, or continuing life-sustaining treatment would not be beneficial, give effect to the advanced medical directive and withhold or withdraw life-sustaining treatment accordingly. If the advanced medical directive names a surrogate decision maker, they should be informed and consulted before giving effect to the directive. What would be, where the advanced medical does not exist? Step 1, 2, and 3 are the same. Alternative step 4, if the primary board and review board are in agreement that initiating, escalating, or continuing life-sustaining treatment would not be beneficial, this should be communicated to the patient's next friend. And through a process of shared decision-making, consensus should be reached that life-sustaining treatment is to be withheld or withdrawn. Once consensus is reached, life-sustaining treatment withdrawn. This where advanced medical does not exist, which is the vast majority of cases.
One more thing I wanted to just ask you.
Yes.
You come to paragraph 198.4.5. 198.4.5.
Yes. Even the hospital board, let's enter.
That's right. And towards the middle of that,
Yes.
the jurisdictional collector shall then immediately constitute a medical board comprising of the CMO of the district concerned as the chairman and 3 expert doctors from the fields of general medicine, cardiology, neurology, nephrology, psychiatry, or oncology with experience. Now, the experts are limited to these branches. You take a case, for example, a pulmonologist dealing with the lungs. You could have a real problem. There's so many problems with lungs. Why is this expert body confined to only certain branches of the field of medicine? We're just wondering, what is the logic?
Yes, it will be unworkable.
Yeah, how would, supposing you have a pulmonologist, you'll bring, you've got a pulmonologist, DM in pulmonology with huge experience. So is the problem affecting his lungs? How do you,
Especially in Corona, that was the main thing.
Exactly. Just, specify it. What is this? Should have been in the concerned field, expert in the concerned field.
But what we are saying is that leave it to the goodness, wisdom of the doctors, because we'll have to go some element of trust. If I've got treating
Because
doctors.
we are now in an age of super specializing.
Yes.
And even more than that. So MD, DM, and above that, you go even further. So if you ask doctors, many of them may not really be able to say, I'll have to look it up. Just like lawyers, I mean, it's not any different. It's the area of specialization. So that's why I thought in pulmonology, I'm giving as an example. There will be other branches where that expert will really know the latest position or the advance made in the research.
Lord, I do this a lot. Suppose I've got a kidney problem, I'll typically be in the nephrological
Oh,
department.
that's right.
So if I'm in the brain problem, in neurology. So basically, my doctor will know that Mr. X, the chances are very slim.
Right.
That's how it works out. The only thing is why we put secondary board after discussing the health secretary.
It's a pathologist.
Hepatologist.
Take an hepatologist, gastroenterologist.
Even colon cancer.
Yeah, not only cancer, there are.
I think instead of complicating it a lot, we simply say a medical board, the doctor teams treating him, plus an independent doctor can certify yes. And by advanced directive is not, which is the vast majority of cases applicable throughout the country. Today, what happens is the next of kin can tell this thing that instead of we deciding, let the primary board decide. Shift the decision making to a primary board. If the primary board decides it can't be done, and Manipal Hospital has done a very good example. Or should we just take page 46 of this spiral bond compilation? What is medical futility? We cannot go into today, but there's a lot of literature where there's medical futility.
We can do one thing both.
Yes.
Have a primary and a subsequent board.
It's
called review board.
Review board.
Can be comprised to one. And take the independent doctors which are referred to 98.4, just read over to you.
Yes.
Which is or.
Yes.
Not all the doctors should be there. Looking to the nature of ailment which we are suffering. Take that doctor. So it is not all doctors. Doctors of either of the field looking to the kind of ailment for which he is asking for expert opinion.
Yes. What you're saying is, suppose it's a, say, for example, a kidney problem.
Yes.
Apart from the team,
Say
there will be
nephrology.
independent nephrologists who will come and.
Correct.
That's a good idea.
This no 98.4.5 takes so.
Yes.
It only comprises of these kind of a broad spectrum of doctors.
It could be any specialization of the person's illness.
Correct. Doctors should be 2 or 3 from these specialties, meaning they were looking to the nature of ailment. Take the doctor from this specialty. This is normally the patients suffer from these very normal ailments, not in general. So what we suggest you, subject to what my brothers also say, make it one board. Primary and review board must become so that it can speed up, simplify, and take a further course of action.
So you're saying one board would be the treating doctors plus an independent.
Independent
That will be
government,
part of the-
CMO or whatever.
Or the senior doctor in that field wherever applicable.
And this code has said 20 years experience.
Doctor says,
This code has said 20 years experience of the doctors who want to be a member of the board. Isn't it very 98.4.5?
no, 20 years, that's what that.
20 years.
That also we said was not possible because in many cases in smaller towns, the doctor may not be have 30, 40 years.
You don't find doctors of pulmonologists and oncologists there.
You may not have. You may not have.
Specialty you don't find. You only find in Chennai or in Bombay. You don't find in somewhere in Rajasthan, Sikar. You don't find it there.
But in fact, Lordship comes to Apollo Hospital in
The
Chennai.
simplest
The board is in English and in Bengali.
Yes.
This two-tier system is introduced with a
And
purpose.
Hindi. Pardon me?
This two-tier,
simplest and most.
this is with a purpose. Because we know that, no, you cannot simply roll off the manipulation likely to happen. So, and especially when you are taking on the life of a man, that is why it is so precious. Much precious than the properties of a man. That is why this two-tier system is staying.
Lordship may think of overnight we'll deliberate upon it. Put a single.
Because it is not that person. Somebody is deciding. Of course, advance, everything is there.
No,
But still,
the reason.
you are taking whether that person's life is to be taken or not. Therefore, it should be.
No, one option is sometimes time is of the essence. Time is important. So time is very, very important. Now, for example, man is going to a coma. What do we do? Only 10 days have passed. So review board may take time. So either we propose for a review board or we
That
say.
is why
In the meantime, the cost
It's not
goes
a
up.
matter which should be
Yes,
done
In
in
the
a hurry.
meantime, the expense goes up, like
Huge.
expense will go. Supposing you keep delaying it. In the meantime, the man is,
But normally, if a man doesn't have enough means to pay for the life support system, what does the doctor or the hospital do?
No, but then they take a form, you discharge like it's medical. I know many cases, especially in a.
they'll ask for a
hospitals-
bigger deposit. They'll ask for a bigger deposit.
Yes.
Initial deposit,
No,
plus
I-
deposit,
I know a case.
some
where-
other bill.
where a
This
person-
is the advance directive from the hospital.
where a person has gone to the hospital, they didn't have the advance money to pay, then they shifted in the ambulance to the next hospital, dies on the way.
He dies on the bill.
He dies on the way.
I said he dies on the bill.
Bill, yes. That's what somebody said, sometimes for a poor person, like Mr. Natraj was saying, It's cheaper to die. There's no money for the treatment. That's
Most
the
of
hard
them die,
reality.
most of them die.
Because we don't have social insurance, we don't have.
All these are for those who can afford those.
That is
kind of
exactly what I
life-saving
was telling you.
life support system.
Constitutes about a 0.0.
No, no, in fact, I would humbly submit that it could be helpful to people who are, say, at the middle class level, who are not completely poor, not completely rich, but they could be ruined because of this.
They would not go in for the treatment.
Not many of them.
After a certain stage,
They will say, please.
the relatives will say, I mean, this, we can't afford it. And if they can't afford it, that's end of it.
Yeah.
Then they have, what's the son? Discharge in medical.
This we are telling you.
See, suppose, 1 minute before you answer, suppose this person, the sick person is, the family doesn't want him to be discharged. Neither they have enough money to put him on life support. So what does the hospital do in normal practical terms?
The document.
Intensivist repellent or less modification. You know, the whole question is this only. We need some guidance for ethical and humanitarian management. That is why it becomes inhuman to continue on life support after a certain.
No, we are posing you a question.
Yes.
Suppose they can't afford it, what are the doctor?
No, if you can't afford it, sir, that is not a reason to take an end of life decision.
No, what is the pay?
What do we do? No, see, if there is no hope,
No,
then
no,
we
no.
have to talk.
Suppose there is hope,
If there is hope,
but no money.
then either we give subsidy or move to a hospital where it's less expensive. If there is end of life situation, then we have to take.
Suppose it's not end of life.
No, if it is not, sir, we can see the left against medical advice is not human. Because we have to.
So because they don't want to leave.
Yeah, and nor do we want to just send a patient off like that because
Then it becomes a contract kind of
it is
situation,
difficult.
commercial decision.
Then we give subsidy. Many times we move the patient to a less
How
expensive.
much subsidy each hospital has?
I'll tell you, sir, there are system. No, I'll tell you.
You have to
I'll give you
basically
example.
go, you just have to go in.
No, sir, I'll give you example.
Harsh reality.
I'll give you. There are some hospitals which move the patient to the free ward. Number two, there are some hospitals which give subsidy up to 30-40%. You know, I don't want to take names, but I can give you exact names where all this is done. But then there are hospitals which don't care.
Anyway, we are not so much concerned at this stage with this factor.
No, at the end of the day, we have 2 points, 143.194.
No, so I want to say only one thing in the context of the end of life care that we are talking about. You know, the end of life care we are talking. You know, sir, actually, there are many people who are on life support or about to be on life support, which they don't need, which is futile. And that is well discussed, well defined. We have got an ICMR which has given all these definitions, you know, what is terminal illness and what is end of life and what is futility, all this, what is inappropriate treatment. All these are well defined and submitted with you by the ICMR consensus. Now, this is also available in international publication. In a situation like this, sir, we don't have too much time. You know, every case is not a vegetative state. Vegetative state gives you months and years. But there are situations where it has to be decided within a few days.
Oh, normally,
The majority, sir, majority of these decisions, end of life decisions, are taken in the first week, and most are taken in the first 3 weeks. This is all there. The data is there. We have submitted those papers also. Therefore, it is unworkable to have any person coming from outside the hospital, you know, and involved in this decision. And this decision is not easy because we have to respect autonomy also. We have to follow the obligation of beneficence also from our side. So there has to be a cogitation. As the previous common cause judgment has said, there has to be a cogitation between doctors and family, and there should be multiple doctors involved. This is what we'll ensure, sir, in the procedure. Multiple doctors, whether 1 or 2 tiers, but they should be within the hospital. And then if there has to be a review, you may have an independent outside person. But since these are time-sensitive decisions within the hospital, we must have within the hospital, sir. Please ensure this because we have been yearning for this for years now. Because we want to take a humane care of the patient. We don't want to abandon the patient at any stage. The patient is dying, we don't want to abandon the patient. Send patients along. We want to care for the patient as per the dying patient's care, as per our palliative care. And so we
now
take care of the pain. And
1 minute. So now who are you?
we means healthcare workers, which means doctors, nurses, healthcare administrators, healthcare policymakers, all of us are involved in caring of the patient and the sensitive caring of the patient, caring for the symptoms, caring for the dignity, caring for the peace of the patient while dying. We are talking about the death and dignities.
That's
Sir, I am right now officiating Director NOTO, National Organ and Tissue Transplant Organization. And I am also looking after the trauma and injury and burns management program of Government of India. So, sir, I have worked in Safdarjung Hospital, government hospital since last 13 years. The issue being raised, see, first you have asked कि once a patient is in private hospital, he or she has exhausted their all the money and all the resources. What is being done? They are being shifted to government hospitals, and in the government hospitals, we get daily umpteen number of such cases. One. Number two, about this advanced directive, sir. Advanced directive is basically a thing which is being asked for the patients who are at the end stage of their life, and it is futile as per the knowledge of that particular time. In the medical science, doctors say that we are wasting our resources on a thing which is going to give us no results. So we want those resources to be utilized for those people who are waiting and who can be saved. So this is the issue for this whole of the agenda. So advanced directive is, as sir has said, the advanced directive is applicable for very, very few people, those who are in the hospital, who are in the terminal stages, and a doctor or treating team feels that they at the present time with the scientific knowledge, it is of no use to prolong the treatment. Rather, it will be better to save the other lives which can be saved. One. Second is this advanced directive.
There's a term for that, I think, during Second World War it emerged. Yes.
So triage is other thing. Triage is basically a thing where
We came across the term during that COVID time.
yeah, triage is something different. That's triage is a term when we have got so many number of people, we prioritize those people whom to take first, whom to take
Anyway,
second.
so this is a bigger.
This is the bigger. So basically,
Bigger track.
it is to help those people who can be saved and don't let the resources based on a person who is already gone as per the present scientific knowledge. One. Now, regarding the boards, sir, two boards need to be there. One. When I'm in a intensive care, I'm basically a cardiac anesthetist. When I am treating a patient, I may have bias. I am giving my 100%. I am engaged with that person. So few element of that personal touch and all these things come into effect. Once the treating team decides that yes, this is the case where our medical treatment is not going to help in any way, so it is always good to take a opinion from the other board. It will remove that bias. So it will be always good that we should be having two boards. Third, this judgment was there, sir, but in the hospitals, what we were facing was process was so cumbersome that it was non-practical. Despite having a judgment, we were not able to implement. There will not be even a single case whether we could have done this in any way. So we need to trust the medical fraternity, sir. It is not a single person who is taking the decision. It is the treating team. And in this team, we are coming up with 3-4 doctors who are part of the treating team. And then once the treating team takes the decision, then it needs to be reviewed by a next team. So it can be done in that way.
yeah.
And that advanced directive thing, I don't know why we are making it so big a thing. Let us say, even in my 30, I write down an advanced directive. Yes, I have written that. It is of no use. It comes to use only, sir, when patient comes to a hospital. He is on a life-saving strategy, life-saving medicine. Then these boards will be taking decision. This will only help in a case when attendants are saying, because at that moment of time, they are not in a position to take decision. They will say, no, we don't want. And this advance directive may help us in taking decision at that point of time. That's only, this is it.
Thank you.
Anyway, so tomorrow we'll come with a.
That's right.
So 194.3 and that 194 that last, how to be affected is multiple boards, etc. We will.
But as the doctor said, having two medical boards serves a purpose.
Yes, yes.
So that, the only thing that can possibly be done, we tell you,
Yes.
we can set certain time limits. Because what is important is, like you said, speed. So once the first board gives a report, we should say that within a particular time, this next board should examine and a decision should be taken.
That is, yes, that's right.
It is this, once you have the, otherwise you can go on endlessly.
Yes.
So it will defeat the whole purpose.
Even our view is also that there shall be two-tier system, two-tier check must be there.
Because every day in the hospital is going to cost.
Absolutely. The whole purpose will be defeated, and like he said, it's a drag on the resources.
Sir, and one, just my colleague, can it be from the same hospital, review board?
Yes, yes. Sir, here I will say ki, if in a hospital,
Yes.
all the specialties are there, we can go with in that hospital. There will be many instances when all the hospital will not be having so many number of doctors, then any nearby government institutions can be involved.
See, again, we'll have to come to a definition of which hospital, clinic,
Yes.
small, big. We'll have to have something uniform.
No, what I was suggesting was.
Legislature can come up with a.
Yes, and the part-time, the temporary, let's put up this, let's start implementing it. Let's see how it works out. Once your lordship gives a workable formula, we will have a.
The only tweaking that really is going to happen is putting up a time limit.
Sir, that will do. And sir, one more.
And some doctors are telling me that sometimes outside review may take time. So
That's why you're telling you.
within, if you can't do
It can be within a time. Sir, second is clarification regarding these specialists, super specialists and general physicians and all those things. Sir, most of the time, these patients are being treated under the care of specialist doctors. So they are under the care of specialist doctor. So in the primary board, most of the time it will be the specialist doctor because intensive cares are being managed by the intensivist and super specialist people. So they will already be under the supervision of these specialist doctors. So in the review board, they should be general people.
You don't find an hepatologist.
They should, the review board should be a general board so that bias is gone. So he is the journalistic person who can.
Gastroenterologist is not there.
Yeah.
Gastroenterologist is not there. We are wondering why.
No, I'm saying let's not give the specialty. We'll simply say the primary
No,
board
It's not there. It is not there.
Correct, it's not there, not there.
Yes.
So it should be, sir, treating team and then it should be reviewed by a general team which is not involved with the care of the patient. Then it will remove the bias.
Can you give us an indication? You were in Safdarjung.
Yes, sir. I am since last.
How many beds are there?
Sir, 2950 beds are right now there, sir.
Normally, how many deaths take place each day?
Approximately, sir, around 15 to 20 deaths per day, sir.
Okay.
2,950 beds.
And then, sir, 15,000 per day attendance of OPD. Then we have got around 2,500 daily attendance in emergency.
We were looking at the number of cases where this review board may have to devote time to.
Yes.
See, you're talking about Delhi, which is fortunately blessed with a number of premier government health institutions like AIMS,
Sir.
Ram Manohar, Safdarjung.
Sir.
You're talking about this being across the whole of India.
Sir.
My brother said, you go to Rajasthan, you go to Madhya Pradesh, you go to any Uttarakhand. I know from Uttarakhand, I went to Aldwani Medical College. I was shocked to know that they didn't have what do you call this, surgery who does kidney surgery. That is.
Urologist, sir.
Urologist. You don't have a urologist.
Yeah.
So despite the best efforts of the government, they were not able to get a urologist because of the difficult conditions there.
Yes.
So every part of the country is not the same.
Yes.
Correct? There's a variation, a lot of variations are there. When you apply it, you'll have to apply all over the country.
Tell us one thing.
Tomorrow.
Doctor, the medical review board. If it's not possible, don't go for medical.
Within the time limit.
Yes, time is an essence. Time is an essence. So yeah, as far as possible, review board is possible. If not possible, that board can take a decision. If not possible, so that
Sir, the issue is that it should be practical.
practical.
I agree with you, sir, but you have said that after specialist, why journalistic? Yes, sir, I will tell you. See, in our medicine, when we do MBBS, when we do graduation, we are taught each and every subject there. So after that time, we choose a field. That this super specialty thing is, I don't agree with it. It is actually subspecialty. It is actually
Your
subspecialty.
personal perception.
They have come up with this sub-specialization, but a journalistic person will be looking after all the, as a journalistic way, he can ask the questions.
Don't put your personal perception
So
here.
he's saying a general physician.
General physician will be the person who knows each and everything.
People go on fighting to get this seat for super specialty.
Yeah, sir, that is because I am interested in that. I want to pursue a particular, see, as in your law, you have different specialization, that there is a criminal law that.
Let us not go into all these issues now. Tomorrow we will come out with the proper solution, what can be done once and for all. We will not debate upon it.
Just for 2 minutes, put the matter in perspective. So in this very case, your lordship has held that a person in his sound mind and conscious state has an indefeasible right. Several paragraphs deal with it. Final conclusion also says to refuse treatment of any kind. So even to your lordship's question, suppose I say that look, some doctors are telling me that there are very good treatments for my cancer. I don't want to take chemotherapy. I have an absolute right to refuse it, and nobody can force me to take it. This is one clear proposition laid down in so many words in several places in this judgment.
No, it doesn't say that. It says,
Absolutely.
no, it says that it has to be found that he has reached the terminal stage.
No.
Yes.
Not at all. Not at all.
Yes.
That's only about the advance directive.
That's what
Now, your lordship may just-
we are about the advance directive.
No, I'm not on that. I'm saying that in general, one has an absolute indefeasible right in a sound state of mind
Correct.
to take a decision not to take any medical treatment.
That's right.
That's an indefeasible right.
Nobody can,
Yes, correct. We are now dealing with only a very peculiar situation.
Very narrow area.
And the narrow area is where I am not in that state of mind to take a decision. And my wishes are required to either override the wishes of my primary caregivers
Correct.
or override
Medical.
obligation of hospitals. Hospitals are faced with this problem that even when a person is in a terminal state, they are unable to withdraw life support, etc. He says that they are sent to a government hospital. So they are unable to do what they should be doing in order to devote their resources to more productive people. So it is only in those
There is one more thing to it. Not all hospitals who are actually paragons of virtue, because there are many hospitals who put them on the ventilator. Perhaps they are dead. Even after a long time, they come with huge bills.
Yes, absolutely.
It happens.
Absolutely.
Not all
There, of course, the primary caregivers
Yes.
can take a decision, but the problem is primary caregivers feel sort of morally in a dilemma.
Correct.
Well, how can I withdraw life support? This doctor is saying, even if that person has expressed a clear wish, saying that, look, I don't want to be put on a ventilator. Suppose I just say, I don't want to be put on a ventilator. I am giving this in writing right now that should a situation arise, whether or not the doctors say that I can be saved, I don't want to be put on a ventilator. I respectfully submit, my Lord, that declaration has to be honored. Nobody can override, not even his relatives, nor the physicians can override the declaration if it is clear that he has said it.
Could you explain 198.6.2? Please read that. We are all saying this. Kindly tell us what is the meaning of this 198.6.2.
So,
Please read that.
198.6.
6.2 at three.
Advance directive shall not be applicable to the treatment in question if there are reasonable grounds for believing that circumstances exist which the person making the directive did not anticipate at the time of the advance directive and which would have affected his decision. That's all right.
What
But
is the meaning of that?
meaning is that whatever may be the meaning of that, I am saying if a person,
We have to understand
if
it.
a person says, "Hey, look, I am aware," suppose he says, "I am aware that there might be future treatments which might save me, but I, on principle, do not want to be put on a ventilator. I do not want to take any chemotherapy drugs." Suppose he says that very clearly, says that, look, whatever treatments may come in the future, anticipated or unanticipated, I do not want to be put on chemotherapy. I do not want to be put on a ventilator. And my wishes should be honored. If it is clear that this is his expressed wish, and then, my lord, what this does is, it just overrides the decision of his next of kin, who may want to put him on a ventilator, or the hospitals who for commercial reasons may want to keep him on a ventilator. So therefore, it overrides all that.
Provided it is terminal. Again, we are telling you, unless it is terminal, this court has not said it should be.
Your lordship is right. Your lordship is right.
We have discussion with the ministry and other people, they said, that's why the primary board can override the advance. They may say, no, we can be treated.
Absolutely.
Sir, here I will like to submit what sir is saying is, there is a sect in world which is known as Jehovah. They have religious obligations that they will not accept any outside material in their body, and we respect it. But this is beyond this, I think. Right now, we should think about the people who are terminally ill and are being, doctors are being forced to continue the treatment where it is futile. So that is a subject in itself.
One thing is mine.
Yes,
If your statement is taken at the face value,
yes.
what about the medical negligence then?
Medical
Medical negligence. Negligence.
negligence.
Day in and day out, doctors are being tried for medical negligence
That is why.
and he's
this-
asking that because his will has to prevail upon.
Yes,
And
yes.
doctor is not to treat him.
So they will be
Over the
relieved. They will be
You will trouble
relieved.
tomorrow.
They will be relieved of this charge of medical negligence because they are just obeying.
So many
his
matters coming to
directive,
us.
which is ordered to be obeyed.
If he can be treated, then his will as per 98.6 has to be taken.
Lord, that's the problem.
No,
This is the
sir, as long as patient is conscious.
Datta, this bench is concerned, equal strength, 5 judges. There is a 5 judges bench. This application is more to see that if it can be tweaked a little bit. Modified. We can't go beyond that.
Yes.
We must, basically, we can't, otherwise this will be a re-hearing, not a review.
We go to 7 judges.
All that we can do is to make it practically possible, but at the same time adhering to the safeguards.
We can fill up the vacuum, that's all, nothing beyond
That is
that.
all, nothing
The
else.
problem is, my lord, that the safeguards have become so onerous
Correct.
in terms of judicial magistrate, first review board, second review board, etc., that they have become totally impractical, with the result that there is not a single case in this country in these 5 years
Which has really happened.
which has really happened. So therefore, what's the use of giving these elections?
They were not accepting.
Look into the paragraph 202 onwards, 202 onwards and again 202.10. There it says it has to be stated without a trace of doubt that the right to live with dignity also includes smothering of the process of dying in a case of terminally ill patient or a person he previous with no hope of recovery. All those things are dealt with under 202, the conclusions, that also is.
That is mandatory.
We are saying these are all,
For afternoon, the lordship will.
Afternoon, we will be taking item number 2.
Yes, no, I think this, we can have it tomorrow at 2 o'clock.
Tomorrow, it should be over by tomorrow.
At 2 o'clock, no? Because this spills over.
2. So that by the time the operation,
We get also time to
because, yeah.
deeply observe.
is unserved. That is Union of India. Sorry, Union Bank of India.
That sub-respondent is unserved, you're saying, what is this? Point number 3.
No, union really not a,
Huh?
well, not a necessary party. Bank guarantee has been in cash.
That's right, that's
It may
right.
not be.
They may not be affected by
They
the
will not
legal
be.
issue.
They will not be affected by this legal.
All right.
May it please.
Lord, before your lordship speaks of the matter on the merit first, there's one IA we had filed, IA 152125 of 2022. We filed it as an intervention application because then our section 11 was pending, which we were opposing. But that order has been passed, so we wish to withdraw this application.
Sorry, I didn't get you.
There's an intervention application.
Who are you?
Lord, I am the applicant in that application.
Correct.
Because we were opposing an appointment of arbitrator on the same principle because the instrument was not adequately stamped.
Correct.
However, the division bench had appointed the arbitrator, so.
You're withdrawing
as
that.
per- Yeah.
There is some other party actually.
Yes, Lord.
You're not a party in this.
Not the main party. I was intervening then when it was pending, but now appointment has happened. So I don't want
You're
to
not
pursue
parties
this.
to the suit from out of which the matter arises.
Not,
You're not parties to the
so I just wish to withdraw IA 152125.
IA Rana Council for the applicant. So take his name, raise that the applicant may be perfectly withdraw. The application seeking intervention for stop dismissal withdrawn.
I'm grateful.
My lord, there is another IA 185816 of 2022, my lord. This is an application for intervention. And my lord, we also have matters pending on a similar issue, my lord, which will be impacted by the decision of this honorable court in this matter.
We'll hear you.
Yes, my lord, that's all that I wanted to say.
We can hear that, that's all. We'll get light from us. That's enough.
How many other applications?
Right.
I have one application which
We don't
is
have to
IA
know
199969.
Disposing of each other.
That's right.
We'll hear you in the course of the,
So great.
and provided it's necessary. Supposing you have what you have to say, that's entirely for you.
Mindful of that. We'll be mindful.
The same thing I seek in IA 199969. If at all there is anything we'll add, otherwise we'll.
Absolutely.
Grateful.
Go ahead.
May it please. What's your
So
lordship?
you're going to address us first, you're the amicus.
My lord, I would request your lordships may hear me first because there are two judgments before my lords, my lord.
Yes.
I will, my lord, I've had a lot of thought about this. I've also talked to the appellant also, my lord. I may not agree, my lord, with some part of one judgment and some part of the other judgment also. So, my lord, let me put out the case. Some portions they may not have to respond at all. At least your lordships will get the full picture. I request if your lordships permit, let me, my lord, lay it out and then your lordships may decide
Can be.
that way. My lord. It will be.
I'm for the respondent number 1, my lord. After the amicus.
You're for respondent number 1.
After the amicus completes, my lord.
That is, you filed a section 8 application.
Yes. Yes.
It
After
has
that,
been allowed by the High Court.
Right,
Yes.
right.
In the petition.
Yes.
Correct?
My lord, the matter arises out of a reference in the NN Global case.
Correct.
One paragraph of which is relevant, my lord. I'll read it out. My lord, but this matter has a little wider implication because the issue which is now arising before, my lord, this honorable court and various high courts is really mainly in the section 11 jurisdiction. Because what is happening, my lord, is that there are two opposing views. One view says that if somebody points out to you that a document or an instrument is insufficiently stamped or not at all stamped, you, the section 11 judge, have no choice but to impound and proceed. That's one view, my lord. I would say that's the Garwari view. The other view which has been propounded is that no, this may not be. So, my lord, this is one possibility. One possibility which, and this is the possibility, this is what is being done now by the Bombay High Court. They are following this. But the Delhi High Court, on the other hand, is appointing arbitrators and leaving this question.
Section 16.
In section 16. Two judgments of this honorable court, my lord, have appointed arbitrators pending this reference. There are other cases which are pending where the judges have adjourned the matter to await the reference.
Oh,
so, my lord, this is if I may say so, there's a khichdi, everybody is going their own way. So it is ultimately for your lordships, my lord, to lay down the law one way or the other, whichever, my lord, appeals ultimately to your lord. Now, my lord, that's the practical aspect of the matter, my lord. My lord, one also, my lord, I have in this regard, we have filed 4 volumes of compilation for your lordship's kind consideration. Essentially, my lord, the first volume is of the reference judgments. There are 3 judgments which are referred to your to this court, my lord. One is Garwade, one is, my lord, NN Global, and because intervening between the two, there is Vidya Drolia, and certain paragraphs of Vidya Drolia have been done.
46, what is that?
Yes, those 3 judgments are from the first volume. My lord, the second volume, which we have filed, is in re the Stamp Act. Because your lordships will find that in all these judgments, the focus, my lord, because, sorry to say this, my lord, arbitration appears to be very glamorous. The focus appears only on the Arbitration Act and not much debate or not much disputation insofar as the Stamp Act is concerned. So, my lord, the Stamp Act I will place before the Arbitration Act to understand, my lord, whatever my limited understanding of the Stamp Act. Then, my lord, 1 volume is on the Arbitration Act and 1 volume is on the 2 reports of the one of the Law Commission, of the 246 Law Commission, and 1 high-level committee, Justice Sri Krishna, and 7 or 8 articles, my lord, which I have put in only to show that people have very disparate views and use very sometimes intemperate language also. But, my lord, there are points of view in those articles which go one way or the other. So, my lord, I have also tendered for your lordship's consideration just now, my lord, a note of submission. It's rather detailed. I'm sorry that it's so detailed. It's 40 pages because I have actually referred to paragraphs which are, my lord, to be considered and some quotations. It is only to obviate my lord, the necessity for lot of note taking. I have tried to, my lord, therefore it's a little long. So, my lord, the way the note is organized is this. It's really, my lord, in 4 parts. My lord, the first is what is the scope of the reference and what is the submission I will make for your lordship's consideration. That's a couple of pages. Then, my lord, the Stamp Act, then the Arbitration Act, and only then, my lord, the reference judgments. Because I don't want your lordships to be colored either way by the reference judgments. There are some problems, my lord, in both of them, at least so far as I see. I may be wrong. So, my lord, that is the way that I want to proceed, and of course, my lord, subject to whatever your lordships. So, my lord, the reference, there are 3 paragraphs in the reference order. If your lordship just sees the note, and please pick up, my lord, the reference volume. I've my lord, tendered 1 volume of the volume 1 reference judgment.
Convenience volume 1.
Convenience 1. My lord, there are 3 paragraphs of NN Global which crystallize this particular reference. I'll show those 3 paragraphs. If your lordships first come to page 194, which is where NN Global starts, my lord.
Mr. Banerjee?
Yes.
One question. See, an arbitration agreement is really an agreement within an agreement.
Right, my lord.
So effectively, there are 2 agreements.
Right.
So for the stamping purpose, what would be the valuation of the arbitration agreement? Just
my lord, I can answer that, my lord. For the stamping purpose, my lord, it is not the agreement which is relevant, but it is the instrument.
Instrument.
It's the instrument. Now, my lord, an instrument may have more than 1 agreement. As
the line of cases are there that there are actually 2 agreements so far as
yes, my lord,
arbitration is concerned.
Yes.
One is the main agreement
and one is the arbitration agreement. No difficulty.
What would be the value?
How the value is fixed, my lord, under the Stamp Act, my lord, if there is such a situation where in one particular instrument, my lord, more than 1 agreement is there, or more than 1 subject matter is there, my lord, section 5 and 6 of the Stamp Act deal with that situation, and it is really the higher value, the value of the substantive agreement, which is taken as the value of the instrument. You know, there are methods in the Stamp Act, I will show you also, which resolve it. So, my lord, Stamp Act issue is slightly different and Arbitration Act issue is slightly different. And if we keep them separate, my lord, then of course, my lord, we can match them up. Because the valuation issue, my lord, can be seen really create the Stamp Act. And unfortunately, there seems to be an error in NN Global, my lord, on the Stamp Act, which I will also, my lord, highlight. So that
Will a document which is unstamped, will it be correct to describe it as unenforceable? Or will it be more correct to say that it is inadmissible in evidence?
My lord, I would go with the second and I will place those judgments, my lord. I will show that an unstamped document is a valid document. My lord, it is merely inadmissible in evidence. The underlying transaction is valid and my lord, it is not null and void. That seems to be the problem with the judgment in Garware. My lord, I will highlight that in the first quote. So it is valid, but it cannot be, my lord, admitted in evidence. And
You are actually saying that the invalidity and inadmissibility, they are different.
yes, my lord, I am deeply obliged, my lord. That is really going to be my first point. There is, and because of that, my lord, in an 11.6a situation where the 11 judge only looks at existence, there is no impediment, my lord, to a point, and there is no loss to revenue, my lord. Because one, my lord, we have to balance both. You have to balance the speed of the arbitration. You want to appoint an arbitrator quickly, you want to proceed quickly. And you want to appoint the arbitrator and leave everything with him. On the other hand, Stamp Act is a fiscal statute. And you, at some purpose, being an organ of the state, also want to protect the revenue of the state. So the question is, do you protect the revenue of the state at the stage of Section 11, or do you leave it to the arbitrator, who is also empowered, my lord, under Section 35 to do the same job? So it is not somebody who is escaping, my lord, from the tax net. And there are some very interesting observations in some Stamp Act judgments that it is not a weapon to be used to a recalcitrant litigant, but it is really for the benefit of the state. So, I will come to first the Stamp Act and then this, but I'll just show your lordship the reference. 3 paragraphs of the reference, because that is all that there is. The judgment in NN Global starts in this volume, my lord, at page 197. There are just 3 paragraphs which are relevant, my lord, for our purposes at this stage. This was, my lord, I'm not placing the judgment now. Please come to page 215, where the judgment starts, where the issues are, my lord, framed. That's where the judgment starts. And the 3 relevant paragraphs, my lord, in so far as this reference is concerned, are paragraphs 34 and 56 and 58, 56 to 58. My lordships, first see 34, which is at page 243. (243) says, and I just read it, we doubt the correctness of the view taken in paragraphs 146 and 147 of the 3-judge bench in Vidyarolia. Consider it to appropriate. Refer the finding in para 22 and 29 of Garware, which has been affirmed in 146 and 147. So, my lord, 4 paragraphs have been highlighted. I will be focusing on these 4 paragraphs later, my lord. These are the 4 paragraphs that the 3-judge bench seems to have disagreed with. And I would say, my lord, correctly disagreed with these paragraphs. And then, my lord, the last page of the compilation at page 252, the last 3 or 4 paragraphs, and the question, my lords, is formulated at paragraph 58. Lordships, got paragraph 58? That's the last page. Whether the statutory bar contained in Section 35 of the Stamp Act 1899 applicable to instruments chargeable to stamp duty under Section 3 read with the schedule to the Act would also render the arbitration agreement contained in such an instrument, these words are a little problematic, which is not chargeable to payment of stamp duty, as being non-existent, unenforceable, or invalid pending payment of stamp. This is how the question has been formulated. Now, my lord, if your lordships are pleased to just look at the note which I have handed over. My lord, I've just read out these 3 paragraphs in page 1. And then, my lord, my submission, such as it is, which of course your lordships, I'm sure will not be acceptable to many on this side of the bar, but maybe some may accept this, my lord. So in 6 or 7 points, my lords, I have tried to summarize my submission, which I will, my lord, try and make good. Under section 11.6a, which is the section which your lordships will be looking at, the court appointing arbitrator shall, notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of the arbitration agreement. Now, this is the statutory requirement, injunction and interdict.
By information 6A, section 11.
6A, my lord, has been deleted.
Not notified.
But not notified.
So, my lord, examine the effect even after decision.
Yes.
A is a different context.
6.
It leaves no room for discretion to examine, judicial discretion.
My lord, after.
But an application is filed, you have no option but the.
My lord,
after agreement contains the clause of arbitration, appointment of arbitrator.
Right. In fact, my lord, 11.6a deletion and notification will mean that this matter will completely go away from the courts and be relegated to institutions. That was the thinking of the high level committee. But my lord, as on today, 11.6a continues. The deletion has not been notified.
And if it is notified, then what will be the effect?
My lord, the change will be that really this jurisdiction of 11 will be taken away from all courts and vested in institutions which are, my lord, as it were, notified and, my lord, as per the Supreme Court or the High Court, will then, my lord, approve such an institution, and that institution, whatever, my lord, institution will be, will actually just make the appointment. That seems to be the trend which is now going, because, my lord, I want to say one very interesting thing which is not here, which is that there are 85 countries in which there is the model law. This Article 11 is there in 85 countries. My lord, there is something called case law on ancestral texts. I'm the one of the national correspondents. No other country in the world has any jurisprudence of any worth on Article 11, on Section 11. Yet, I'm before a constitution bench, my lord. We were before 7 judges in SBP. Section 11 has been amended multiple times. My lord, why? My lord, I'll answer this question at the end as to why we are suffering from this Section 11 problem. My lord, there is
judicial overreach.
No, it is not the court's fault. My lord. Every time we think it is judicial overreach. My lord, I'll answer the question now. In every other jurisdiction, there is a Section 16 appeal. There is an Article 16 appeal. In every other jurisdiction, there is a full Article 16 appeal. So all these questions go to the arbitrator. If the arbitrator gets it wrong, the court may or may not intervene in 16. But we have footballed it right to the beginning so that your lordships are bothered with Section 11 applications day in, day out. Long judgments are written, long debates are there, and my lord, we are before my lord. That was never the intention of Section 11. That was never the intention, and the statute also makes it clear that you are to confine, my lord, the word is confine. Nobody's seen the word confine. Confine to the existence, to the examination of the existence of the agreement. That's all. That's the Lakshman Rekha. Nothing more. In fact, my lord, I quoted Justice Korean in Duro Felguera, where he puts it in 2 lines, my lord. He puts it so beautifully. If your lordship sees page 2 of the note, after the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. My lord, I've quoted it, my lord, in the second page. Page 4, my lord. Page 4, my lord. I've quoted this passage. Your lordship just sees this passage. After the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. In the synopsis, my lord, page 4. Would your lordship want to see it from the judgment itself? The legislative policy and purpose is essentially to minimize the court's intervention at the stage of appointing the arbitrator This intention as incorporated in 11.6a ought to be respected. Well, this is according to us the correct understanding of the legal position. As an 11 judge, you will look and see.
What would be the effect of this exercise if 6A is notified?
Sorry, madam?
If it is notified, then what?
This exercise will then, my lord, be done by the institution.
No, no. What will be the effect of this exercise undertaken by us after 6A is notified?
My lord, the exercise undertaken by your lordships today will dispose of a very, very large number of, my lord, cases. There is resistance to this notification because there are no, my lord, institutions which the government is comfortable with giving this power.
Court or no, it understand the thing is, it's going to be agnostic, whether it is court or whether that body.
Right.
The same problem will remain.
Same problem will remain. But there, my lord, there will be no problem because nobody will go to them, nobody will argue stamping, nobody will argue a court satisfaction.
Maybe.
They will appoint.
We don't know what they will argue.
How do you know nobody will be arguing?
We can't be
My lord, because we have some experience, my lord, of all these international institutions. They have some rules, my lord, which are framed like SIAC, LCI, etc., etc. They only look at whether there is an agreement, there is a clause.
You know, if we hold, just like the court, I mean, as far as the court is
Yes.
concerned, look at the question whether there is exists an arbitration agreement,
Right.
whether it is stamped, what is the effect of it not being stamped, will be looked into by the arbitrator.
Right.
Section 16.
Right.
Then the same principle will apply.
Same principle.
To the
Same
other
principle.
body.
Same principle.
Will come of the decision.
Practically, nobody will.
Practically, my lord, I must tell your lordship, nobody does it. Practically, I'm only, my lord, explaining, my lord, what practically happened. In fact, my lord, this appointment of arbitrator was never meant to be such a, my lord, big thing. After all, it only happens to fill a gap. Normally, you appoint by consent. It is only when there is no consent or some deadlock that the court is dragged in. So this was really a stopgap, my lord, to break the deadlock. So, my lord, our submission is, my lord, my submission is that, if your lordship just see page 4, as my lord Justice Ravi Kumar pointed out, the existence or validity of an arbitration agreement is not affected by the provisions of the Stamp Act. Non-payment of stamp duty will not invalidate the instrument because it is a curable defect. And, my lord, the submission that I will advance is that 11.6a, my lord, is really a matter which is to be left to the arbitrator, and the arbitrator has the full power, my lord, under section 35 to impound, stamp, etc., etc. In fact, the expression used in the Stamp Act itself gives the arbitrator power to do so. My lord, I also submit that neither lay down the correct law, and then your lordships may, my lord, decide the question in a sense in a clean slate. My lord, with this background, would your lordships now look at the Stamp Act?
There's just one clarification we wanted to. We come to page 234 of your convenience compilation.
Please, my lord.
There, the judgment of Justice Ravindran in the SMST case.
Yes, my lord.
One example which he gives, or an instance which he gives, which is at para 15.
15, my lord.
15 of NN Global.
Correct.
Please read para 15 of 15 because both are para 15.
Both are para 15.
So if you just read that portion, but where the contract is.
Instrument is voidable at the option of a party as under section 19. The invalidity that attaches itself to the main agreement may also attach itself to the arbitration agreement if the reasons which make the main agreement voidable exist in relation to the making of the arbitration agreement also. So, my lord, this is.
Just give that example. Just he deals with the example.
Yes, ma'am. For example, if a person is made to sign an agreement to sell his property under threat of physical harm or threat to life, and the said person repudiates the agreement on that ground, not only the agreement for sale, but any arbitration agreement thereon will not be binding. Well, Lord, I assume this is correct. But then the only question arises whether this issue of, my lord, whether. Yes, that's really the question. Of course, my lord, in fact, 16 uses 3 words. It says existence, it says validity, and it says jurisdiction, which is wider than existence and validity. So, my lord, these are typically questions which will require evidence, whether he has been threatened with duress, etc. So it will go to 16. There's no difficulty with this.
No, the point is that, in such a case, there is no question of, this duality of existence of two agreements within an agreement.
It is the same agreement.
It will be one brush will paint everything black.
My lord,
the whole thing will fall to the ground.
My lord, in fact, this competence also has its limits.
That's right.
But there is a role for competence, my lord. In fact, there are some very interesting passages of Justice Thakkar in the dissent in SBP Patel. He was the single dissent. My lord, the idea is that there is a scope for competence. It is reflected in section 16. It is really only limited to give the arbitrator power to decide questions which go to his jurisdiction, and for that purpose, you may have two separate agreements. The question is, I don't know how far you can stretch that legal fiction. We'll come to, my lord, we'll come to section 16 and I'll address your lordships on competence also. But my lord, first, if your lordship sees the Stamp Act, well, nobody looks at the Stamp Act, my lord. Unfortunately, everybody looks at the Arbitration Act, and my lord, I confess I also fell into the same trap when I started. We all look at the arbitration law. So if you so your lordship looks at few provisions. I have summarized, my lord, my submission on Stamp Act in a few pages in the note. My lord, if your lordship just first see the provisions. Do we have you given a copy? So we've handed over copies of the stamp. Well, let me first see section 211.
Instrument.
Lordships have two subsection 11. Duly stamped as applied to an instrument. So one of the stamp goes with the instrument, means that the instrument bears an adhesive impress stamp not less than the proper amount. Such stamp has been affixed. So, my lord, 211 is on duly stamped. Then, my lord, 214. Instrument includes, there are A, B, and C. And C is, my lord, any other document mentioned in Schedule 1. Now, my lord, the way the Stamp Act works, your lordships will know is that if it is entry 91 of list 1, then the central government, my lord, imposes the stamp. And if it is, my lord, entry 63 of list 2, my lord, all this is mentioned in the note, then it is either the state brings in an amendment, Schedule 1A, or in certain states like Maharashtra, etc., there is a separate Stamp Act. My lord, there are some minor variations in language, but according to me, my lord, it will not make any difference to the question of law which falls for your lordship's consideration. Now, my lord, your lordships have seen 211 and 214. Please see section 3. Now, this is a little important. Section 3, your lordships will see. Under the heading stamp duty, liability of instrument duty, subject to the provisions of this act and the exemptions contained in it. So, the following instruments shall be chargeable with duty. So, my lord, what is chargeable is the instrument and not the transaction. And, my lord, we have put in the note, my lord, a judgment of the Court of Appeal of Lord Esher. I'll just tender that, which has been followed with approval by the full bench of the Allahabad High Court. Justice Suleiman, as he then was, followed the judgment. The reason I'm emphasizing instrument, my lord, is because, my lord, there is a confusion between instrument, my lord, and the transaction. My lordship just sees this. This is 1889 23 QBD 579. Not just to give the background as to what was there in the case, but the entry in the schedule or in the Stamp Act was that the party was required to pay stamp on conveyance or transfer of sale, transfer or on sale of property. So what the parties did was they did not enter into a conveyance or transfer sale. They merely entered into an agreement to sell. They did not further enter into the actual conveyance by which the property was to be sold. So the commissioner said, sorry, you should pay stamp duty on this. The Court of Appeal said, no, it is what is said in the entry and the instrument and not the underlying transaction, which may effectively be a transfer. So, my lord, I'll just read the head note and 2 paragraphs of this judgment. The head note says, schedule to the Stamp Act imposes ad valorem duty on every conveyance or transfer sale of any property. By section 70, terms conveyance or sale includes every instrument and then held, affirming the judgment of the Queen's Bench, an agreement for the sale of goodwill of business, effect which in equity as between the vendor and purchaser, make the purchaser the owner, which a court of equity decreed specific performs in event of vendor and fulfill, was not within section 70, not liable to duty. So, this was the ratio of the judgment, but I am not on the ratio of the judgment. Please come to the passage which we rely on, which is at page 589. Should have 589. In this case, the Commissioner in Indian Revenue decided ad valorem stamp ought to be attached to the instrument in question. Divisional Court overruled their decision. This appeal is brought by the Commissioner. Now, the first thing to be observed is when the legislature assumes to impose tax on a subject, must do so in clear and distinct terms. If the matter remains in doubt, subject to entitled judgment. Subject to that observation, the question is whether the instrument was laid before the Commissioner, conveyance on sale within the meaning of 70th Stamp Act. That section says term conveyance on sale, and Malod, the section is quoted. Now, Malod, this is the sentence that we rely on. This is 3-4 lines here. The first thing to be noticed is that the thing which is made liable to the duty is an instrument. If the contract of purchase and sale or a conveyance by way of purchase sale can be or is carried out without an instrument, the case is not within that section and no tax is imposed. It is not the transaction of purchase and sale which is struck at, it is the instrument whereby the purchase and sale are effected which is struck at. And if anyone can carry through a purchase and sale without an instrument, legislation could not have reached that transaction. So, my lord, the short point of this judgment is, and my lord, this is followed in that full bench of the Allahabad High Court. Short point is, Stamp Act hits at an instrument. That may be relevant for the argument of competence, etc. Stamp Act is not concerned with the transaction. If the instrument is there, it fits the schedule, you have to pay. So, this is one aspect which I thought required clarification. Now, my lord, so test 1 is instrument. Step 2 is it in the schedule? Now, my lord, here, unfortunately, there is appears to be an error in NN Global, because NN Global holds in 2 paragraphs that an arbitration agreement is not liable to stamp duty. And, my lord, the question which is framed for your lordship's reference also appears to carry that error. So, my lord, I just first want to show NN Global 3 paragraphs where there is a problem, and then, my lord, show the schedule which shows that the agreement, my lord, is arbitration agreements are covered. There are judgments also, 100-year-old judgments, which say arbitration agreements, even, my lord, separately may require to be stamped, because after all, an arbitration agreement is also an agreement. There cannot be any dispute about the fact that it is an agreement. So all agreements required to be stamped under.
Which are those provisions in the Stamp Act?
My lord, we've set it out in the note, my lord, Article 5.
Article 5.
Article 5.
Let us see that.
That, my lord, is, my lordship sees the
because they were dealing with the Maharashtra Stamp Act.
Same article.
It's the same.
Same article. No. Article 5 is the same. Article 5 is the same.
Indian Stamp Act, Article 5C is a residuary provision, whereas in Maharashtra it is 5 small h capital B, if not otherwise provided, 100 rupees.
All acts, my lord, I have seen 7 or 8 acts, they all have this residuary provision. 5C in the Indian Stamp Act is reflected in,
Let us see that.
well, not page 43 is where the schedule starts. And 5C is agreement, 44, my lord, agreement or memorandum of agreement if not otherwise provided for. So, my lord, the assumption in NN Global that an arbitration agreement, even a standalone arbitration agreement, is not liable to stamp duty may not strictly be correct. And to that extent, my lord, your lordships will have to. My lord, the three places where it is mentioned, I'll just show, my lord. Your lordship may just note para 20, 24 and 58 where the question is being formulated.
You have the Maharashtra Act, Stamp Act?
Yes, no.
No, it's been filed by my friend.
Same, similar, it is similar?
It's a bit different. The residuary is the same.
Residuary is
Residuary is same. Instead of 8 annas as under the Indian Stamp Act, it is rupees 100.
Whatever
That
it is.
is, it's, in fact, your lordships may just see the convenience compilations, one filed by us, the Maharashtra Stamp Act.
That's 12 is good. 12 is good.
Your lordships may straight away come to page number 21, convenience compilation 1, filed by me. It is agreement or its records or memorandum of an agreement, and then H B, if not otherwise provided for.
I've looked at 7 or 8 acts, all of them appear to have this residual clause.
So the basis for the reference order to find that it is not exigible to stamp duty is not
at all. That portion, my lord, is not correct. I'll just show that, my lord. If your lordship sees the my compilation reference
We have
judgment.
seen that, we have seen that.
So 3 paragraphs, my lord. In fact, the court refers to Article 12 award, but misses this particular article.
Even in that, there's a factual error.
That's not the Maharashtra Act.
That is not the Maharashtra Stamp Act. It is the Indian
It's the Indian
Act
Stamp
award, which is quoted as Maharashtra Stamp Act award.
But my lord, they have not, they have this in 3 places, they proceed on this basis, which is why, my lord, in my note, which I had tendered before my lords, I had deleted 5 words. I had taken the liberty of deleting 5 words from the, my lord, reference order. Your lordships may recast the reference and your lordship just see my note at page 5 for a moment. I had deliberately, my lord, I had said, my lord, those words may not strictly be appropriate, which is not chargeable to payment of stamp duty. So, my lord, the Stamp Act, your lordships have seen the provisions. Your lordships have seen section 3, instrument. Then, my lord, 5 and 6. My lord, 5 and 6, to answer Justice Bose's question, my lord, as to how valuation is to done, my lord. It is 5 and 6 which address, my lord,
5 and 6
of the Stamp Act. Instruments relating to several distinct matters. Instrument comprising relating to several distinct matters chargeable with the aggregate amount. Actually, 6 would be more appropriate.
This court has discussed this. This court also dealing with
5 and 6. 5 and 6. So, my lord, so then your lordships will see 3 or 4 provisions, which are the provisions of some debate, my lord, which are 33, 34, 35 onwards. That is chapter Roman 4. Which starts at page 25 of this scheme. 33, I will come back to 33 and 35 later. But 33, my lord, says, every person having by law or consent of parties, which will include an arbitrator, authority to receive evidence, and every person in charge of a public office, except an office of police, before any instrument chargeable in his opinion or duty is produced, or comes in the performance of function shall, if it appears to him that such instrument is not duly stamped, impound. So this is the provision for impounding. And then thereafter, whatever happens. And then 35 is the provision, my lord, which is effectively the statutory bar, which is instruments not duly stamped, inadmissible in evidence, etc. Instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authorities to receive evidence shall be acted upon, registered, authenticated, unless such instrument is duly stamped. So one of these two provisions, your lordships will have to construe at some point. I'm only flagging them now, my lord, because there will be some debate on this. Then, my lord, then 36 is important. If you have actually admitted it, then you cannot question it. 38 is the procedure for dealing with impounding. And, my lord, 42 is endorsement. I have mentioned all those provisions, 40, 42, my lord.
The proviso in 35 also you can read.
35 proviso, my lord. Provided that any such instrument shall be admitted in evidence on payment of the duty with which the same is chargeable, in case the instruments are insufficiently stamped, the amount required to make up such duty, together with a penalty of 5 rupees, or 10 times the amount of the proper duty, deficient portion thereof exceeds 5 rupees, sum equal to 10 times such a duty or portion. So, my lord, that 5A is there are some exceptions also, my lord, in 5 BCD, but this A effectively, my lord, provides the procedure. You pay the amount, you pay the penalty, and you get it. So, my lord, this is so far as the provisions of the Stamp Act are concerned. Now, my lord, insofar as the Stamp Act is concerned, my lord, I have culled out a few judgments which throw, in my respectful submission, some light on this. Note I'm at page 8 of my note at the moment. Pride of place, of course, is given to, my lord, our Supreme Court, then, my lord, the Privy Council, and then some High Court judgments, and then one judgment from one foreign jurisdiction, my lord, which one of my, my lord, juniors very, my lord, discovered, and I found it to be very, my lord, interesting and appropriate. But I'll come to that later. My lord, the first judgment that I would bring to your lordship's attention is this Hindustan Steel judgment. Lordship, take volume 3.
There is convenience compilation part 1.
Yes, Manoj, this is part 3, which is the Stamp Act. The first judgment in this compilation, judgment called Hindustan Steel versus Dilip Construction Company. Now, this was also an arbitration case. And Manoj, the facts in paragraph 1 have some relevance. I just place paragraph 1 now. Respondents entered into a contract with Hindustan Steel, raising, stacking, carting, and loading into wagons, limestones, Nandini mines, dispute which arose between the parties. Arbitrators differed. I'll skip to about the 6th or 7th line. One of the contention raised by the appellants was that the award was unstamped and on that account invalid, illegal, and liable to be set aside. Have your lordships got that sentence in the middle of the paragraph? Thereafter, my lord, the matter comes up, the district judge impounds it, duty is to be paid, etc. It comes up to the Supreme Court. My lord, please see para 2. Urged by counsel for the appellants, an instrument which is not stamped as required by the Indian Stamp Act on the payment of stamp duty and penalty to be admitted in evidence but cannot be acted upon for the instrument, quote unquote, as quoted, my lord, by the dishonorable court, instrument has no existence in the eye of law. The argument was it had no existence in the eye of law. Then, my lord, the Supreme Court sets out various provisions. I've read all these provisions. So I'm not going to trouble your lordships with all these provisions. Please straight away, my lord, come to paragraphs 5 to 8. No, I'll just read para 7 rather than the full portion. I'll just read para 7. The Stamp Act is a fiscal measure enacted to secure revenue for the state on certain classes of instruments. It is not enacted to arm a litigant with a weapon of technicality to meet the case of his opponent. Stringent provisions of the Act are conceived in the interest of the revenue. Once that object is secured according to law, the party staking his claim on the instrument will not be defeated on the ground of initial defect in the instrument. And then, my lord, the provision, the Act is analyzed, and the Supreme Court says that the document having now been stamped, it is valid, etc. The relevance of this is it explains really the scope of the Stamp Act. That the purpose of the Stamp Act is really to protect the revenue and not to give a weapon to a litigant. And once that aspect is protected, then the parties taking the claim on the instrument will not really be. So, Molo, this is one step of the way. The paragraph 8 refers to a judgment of the Allahabad High Court. In fact, the minority view, which is not accepted by the Supreme Court. I put that in just for the sake of them. This was one view, this was the view which has been taken in Hindustan Steel.
But this is after impounding.
This is after impound. Yes, ma'am. This is after impound. The lordship is right. Now, my lord, I go one step further. So this is after impounding. You can cure the defect. Now, my lord, if your lordship goes one step further,
that proposition possibly there
cannot be any dispute. So, my lord, the other two judgments of the Privy Council and the Patna High Court, which I have noted in page 8, my lord, also effectively say this. So, my lord, I am not going to trouble your lordship. I mentioned the passage and the portion from the judgment. I am not going to waste your lordship's time unnecessarily on this aspect. My lord, the question is a little different. The question is, supposing there is a document, it is not stamped, it ought to be stamped, or it is inadequately stamped. What is the legal basis of that document? Is it
what is argued, sir?
Sorry,
11.6. Any application,
right?
Court is to see whether there is an arbitration agreement or not.
Right.
Now, normally that agreement is annexed.
Right.
Does it not assume the character of an evidence?
My lord, I will say this.
Because then it would become inadmissible and look into it.
Yes, my lord. In fact, your lordship will have to read what you mean by the word existence, what do you mean by the word validity. All different expressions have been used in the Arbitration Act. Very interestingly, existence has been used somewhere, validity has been used somewhere, jurisdiction has been used differently somewhere, arbitrability has been used. I'll show that, my lord. So, my lord, because really a section 11 court, my lord, in some senses is a court,
ministerial court anymore.
Is my lord,
is a mind applying court.
My lord, the question is again, my lord, we should not fall into the question of judicial versus administrative. My lord, I would rephrase the question. I would say what is, and that is how the Law Commission says, what is the scope of inquiry of the 11 court? What is his scope, his or her scope? That's the expression, my lord, which is used.
Scope what is whether there is an arbitration agreement or not.
My lord, in fact, I will show, my lord, there is an emphasis on the word existence. The legislative history shows that the words used are, my lord, very interesting. Confine, first the word confine, namely, my lord, you are limited to the examination of the existence of an arbitration.
Yes. Now, where do I find that one? Where do I find that arbitration agreement?
My lord, in the document, no difficulty.
In the document.
My lord,
The document is produced as an annexure.
right, my lord, but your lordships are not
Treated as an evidence.
Right, my lord, my lords are not admitting it into evidence in the way that you are required, my lord, under 33 or 35 to do.
Summary proceeding like in REIT.
Right, my lord.
All
My
the
lord,
annexures are also evidence.
my lord,
And they are affirmed on oath by the verification.
let me, my lord, tackle that.
Anyway, you go on.
No, I understand. My lord, the question really is whether you can even look at that document, because by looking at it, you are admitting it into evidence. I will show, my lord, that there are different phrases which are used and different ways it has been understood. And the legislative history will show to my lords that what you are really required to look at, and that's also in Vidya Rolia, is that yes, you have to satisfy yourself that there is a concluded contract. You may have to satisfy yourself that there is consideration, some formal requirements you will have to satisfy yourself. But in the process of looking at that document, it will not be going to the next stage of admitting it formally into evidence and deciding on, my lord, the or even, my lord, acting upon it in that fashion. I'll show the, my lord, relevant. I'll show the history of it to satisfy your lordship, because, my lord, it all depends on how you read that phrase. Existence could be read widely. Could be, my lord. It could be said that existence of an arbitration agreement may include whether accord and satisfaction was there or not, because an arbitration agreement ceased to exist because there may be subsequent accord and satisfaction, or agreement exists but limitation bars. This could be, my lord, existence could be wider. Not, I'll come to that. My lord, if I could just go back to the Stamp Act, and then I'll immediately, my lord, come back to that. So, my lord, one is what happens after impounding. That's my lord, unexceptional. What happens pre-impound? Supposing a document is not impounded, what is the value of that document? Is it waste paper? Is it relevant? Is it irrelevant? My lord, to answer that, my lord, we have carved out, my lord, we have mentioned 3 or 4 High Court judgments and one other judgment. I'll just place those judgments, my lord, as to where is the line which is drawn. So if your lordship comes to page 9, lordship come to page 9 of the notes, and please come to Joyman Beva, which starts at page 31.
Page 31.
31. Well, the relevant portion I'm not reading the facts, Manoj. But this was a document, Manoj, which was not stamped, and it ought to have been stamped. Now, please come to page 33.
Just 1 minute. Yes.
33, Manoj, somewhere in the 3rd paragraph. In both the lower courts, documents exhibited and evidence marked as an exhibit. Lower appellate court dismissed the application on the ground that inasmuch as the contract of suretyship was not duly stamped, it was not valid as a contract. And not further held other things. So the lower appellate court dismissed the application because the document was not duly stamped. On further appeal to this court, the contention that the contract contained in the petition was rendered void because it was not duly stamped, was not persisted in. In my opinion, there is no substance in the contention. Failure to duly stamp a document which must needs be stamped by reason of the provisions of the Stamp Act does not affect the validity of any contract therein contained, but renders the document inadmissible in evidence. This is the line of distinction that we are seeking to draw. Assuming you are confronted with a document which is liable to be stamped, it is not admissible in evidence, but it doesn't mean that the contract, the the contract ceases to be valid. So, my lord, that principle, my lord, there are a couple of other judgments, my lord, which say that if your lordships then see page 36, it's a little more elaborate, my lord. One portion of the judgment your lordships may ignore here. It is volume 3.
Part 3.
Lordships have it?
You got a stamp, I think. That takes a stamp as well, say, now you're going to. Yeah.
Now, the second judgment is at page 36. There are some interesting questions of etiquette and English bar that you should not raise such questions, my lord. That can be ignored for the purposes, my lord. That is no longer the practice, that you should not raise such a question because it is not appropriate to raise such a question. That portion of the judgment your lordships may not look at, but the reasoning on the substance is at page 39. At the top, Mr. Basu's first contention on behalf of Phulchand and Muralidhar, the document is not valid, not properly stamped. No substance in this contention. Then, my lord, section 35 is set up. Effect of the section is to make such an unstamped document inadmissible by evidence, unable to be acted on by person. It does not affect the validity of the document. There's a clear distinction to be drawn between invalidity and inadmissibility. Certain statutes and sections render documents invalid if they are not stamped. No section of the Indian Stamp Act has this effect, instant of a document being rendered invalid by the omission of stamp contained in the English Stamp Act. And my lord, he gives an example of the English Stamp. So, my lord, this is another judgment, and then there is a third very similar judgment by at page 43, my lord. This is by Justice Bijon Mukherjee, as he then was. And, my lord, the relevant portion is at page 47, where he summarizes it in one paragraph at paragraph 15. Your lordship, see paragraph 15, page 46. Here, the document could not be stamped because the gentleman died. So the document could not be stamped. And it was argued that now you can't do anything about it. The High Court said that failure to stamp a document has got to be stamped, does not affect the validity of the transaction, merely renders the document inadmissible. We got it stamped. Now, my lord, the most interesting and the last judgment in this section on Stamp Act, which I will show, my lord, is a judgment your lordships will see at page 103. I want to make some comments on this one. It's a very interesting judgment. Please come to 103. Your lordship's got 103. Well, this is a judgment delivered by a gentleman by the name of Turab Patel. He was a Parsi judge who refused to take the oath of allegiance when General Zia-ul Haq came into power and resigned. He would have been the Chief Justice, first minority Chief Justice of Pakistan. He also wrote the dissent in the Bhutto hanging case. So this is and he's a well-known jurist, and all the judgments he relies on in this one are all pre-independence and all Indian judgments. But the way he puts it is very interesting. So there are a number of, my lord, very interesting paragraphs in this. And I'll just place it, just for your lordships to see what is said here. My lord, the issue here again arose out of an arbitration case. What had happened was a defense was taken that after the award was pronounced, a defense was taken that the arbitration is bad, the award has not been properly stamped. The agreement has not been properly stamped. So it is not admissible in evidence, it was not properly stamped, and therefore the award itself is null and void. And the question which was framed, your lordships will find, is at page 105 in the second paragraph at the end. I'll just read that. According learned judge dismiss every appellant file petition leaves the court admitted in order to consider, quote, whether there could be any valid arbitration proceedings in the face of the agreement not being duly stamped in violation of 35 of the Stamp Act. So, this was not a case where the defect was cured. This is a case where the defect was not cured and yet the arbitration went on. Then, he sets out 35. And the passage which I'm relying on, is at page 1, effectively, pages 107 to 109. There are some very nice sentences, here. Bottom of page 107, after setting out all the provisions, there's a typographical error in the third paragraph. Your lordships may please correct that. The only other section, this is the third or fourth paragraph, the only other section which is relevant to this appeal is section, it should be 61. It should not be 66, it should be 61. Then the last paragraph, and now examine 35 in some detail. Prescribes no instrument not properly admitted for any purpose or shall be acted. Now, merely because an agreement instrument cannot be admitted in evidence on any purpose, as because it cannot be acted on the person specified, does not mean that such an instrument is invalid, not irrelevant to observe. Words which I have quoted have to be construed strictly because they are to be found in provision of penal nature. Therefore, it would be against all canons of construction to enlarge the meaning of these words so as to render invalid instruments which fall within the mischief of this section. This is the first thing he says. And then, he gives a number of examples. He says, after all, instruments which are not duly stamped are executed every day. But I venture to think that most persons who incur obligations under such instruments honor their liabilities under such instruments regardless of provision of 35. This is one thing he says. And if your lordships come to 108, this entire passage, my lord, is worth reading. I'm just picking out few sentences. 108, last sentence. These provisions, as well as other provisions in Chapter 4 of the said Act, such as Sections 33, 38, 39, 40, can only lead to the conclusion object of the legislature in enacting the said Act was to protect public revenue and not to interfere with commercial life by invalidating instruments vital to the smooth flow of trade and commerce. And my lord, at 109, he follows the various judgments, Calcutta High Court, English law, etc., etc. So, my lord, this judgment, I've given all the relevant paragraphs, my lord, in the note. I'm not going to read them out. But the language which has been used to explain 33, 35, 38, 39, Indian law, English law, and my lord, ultimately he agrees with the view propounded by the Indian courts and he overrules a judgment of the Lahore High Court post-independent. He says whatever law, my lord, was formulated by us is insofar as the section is concerned, is correct. So, my lord, all these cases establish one thing and one thing alone, that merely because a document is not stamped does not mean, my lord, that the transaction or the contract or the agreement becomes invalid as a matter of law. So, my lord, that is an important conclusion because that will have some relevance, my lord, later. Lord, you just see.
Mr. Banerjee, in this case, how did they do? Because you said here the stamp was not collected.
Stamp was not collected, my lord.
So, how did they deal with that aspect? Because the others, they said that you should collect it.
Collect it. My lord, here what happened was at the award stage, my lord, it was raised. So, by that time, my lord, stamp had been paid on the award. The agreement was unstamped. So, in this stage, the award state had been reached. And your lordship is also aware of those provisions of 36, etc., that if a document is inadmissible and you don't raise the issue of stamp duty, then it is accepted. So, my lord, here there was, on that principle,
Section 36 was not resorted to here.
36 was not resorted to here, my lord, but this was at the award stage. And it was in fact not even at the award stage, it was at the execution stage. So, in the execution, he said it is void. So, the court said it is not void. So, that is, perhaps, my lord, they could have collected the the revenue, but it was,
that's not appearing.
it was not. So, my lord, these judgments, so far as the Stamp Act judgments are there, my lord, I have just summarized my submissions, my lord, in 405 points in page 11. That's the second subject. So, my lords, all we are establishing with reference to the Stamp Act, simply that it cannot be said that that document is a waste paper. It is invalid. Yes, it is inadmissible in law. Not certainly that's a matter of admissibility. That may not be a matter of jurisdiction. Your lordships know the distinction between jurisdiction. So, my lord, with this background, then, my lord, I come to answer, my lord, the question which is put. And for that, my lord, I would first ask your lordships to look at the Arbitration Act. This Arbitration Act has undergone a lot of changes. In fact, my lords, I've had the privilege of being associated with it at various stages when the various changes have been made. And unfortunately, my lord, when we brought in this act in 96, it was brought in a bit of a hurry. And some safeguards in the act, even for international commercial arbitration, were deleted. That's a matter for another day. And thereafter, my lord, there has been one major change in 2015. There has been another change in 2019. There is another change in 21, which is not really relevant. But the two major amendments are the 2015 amendment and the 2019 amendment. So, in fact, my lord, the way it is put in Justice Khanna's judgment in Vidya Drolia is that there are 4 periods. So, he says the first period is the SBP period, which concludes with the judgment in SBP. The second period is post that pre-19. Third period is 2015, 2019, and fourth period is 19 onwards, which has not yet happened. So we are, my lord, in that 2015, 2019 period. So, my lord, first, if your lordship just see the act as it stands today with all the amendments. I'll show all the sections in seriatim. And your lordships may keep in mind that it is not only NN Global and Garwade that is in reference. There are a couple of paragraphs of Vidya Drolia which are also, unfortunately, my lord, tied into this. So that also your lordships may have to look at Vidya Drolia with some care. First, if your lordship sees, first please mark section 2, subsection 3. Your lordships have 2.3. 2.3 I am only mentioning because it has some relevance in the Vidya Drolia matter. This part shall not affect any other law for the time in force, by virtue of which certain disputes may not be submitted to arbitration. My lord, there are certain classes and categories of disputes like Rent Act, like family law, divorce, marriage, crime, etc., which are not capable of going to arbitration. You cannot agree to it. As a matter of policy, you cannot agree to a Rent Act matter going to arbitration.
Essentially, title or status.
Title or status, my lord. There may be. So, my lord, there may be many such cases, but it is, I would say, a way of putting it, my lord, is this concerns subject matter arbitrability. A particular subject matter cannot be arbitrated, whether it is consumer disputes or ABC. It concerns subject matter arbitrability. For instance, my lord, in Vidya Drolia, the issue was whether landlord-tenant dispute can be arbitrated. Rent Act dispute cannot be arbitrated. The question was whether landlord-tenant disputes other than Rent Act disputes could be arbitrated. The court said yes. But, my lord, it was the subject matter which was in question. So that's why I'm showing 2.3. Then your lordships will see a very, very important provision, 5. Now, 5 is at the heart of this legislation. Use that. No, that 5, not 5 is taken from Article 5 of the model law. This will have some bearing on, my lord, the jurisdiction of the 11 judge. Notwithstanding anything contained in any other law for the time being enforced, matters governed by this part, no judicial authority shall intervene except as provided in this part. So, my lord, the purpose of this is to reduce and minimize judicial interference in or I wouldn't, my lord, I think interference maybe is a very harsh word, intervention. The word used is intervention.
Refusal to exercise power under section 11 on the basis of.
No, I'm saying,
otherwise, yes.
Otherwise, yes. Otherwise, yes. It is one factor that your lordships will consider, that the purpose is minimal judicial intervention. 5 reflects that purpose generally. My lord, 11 will have to be read along with 5. Had 5 not been there, then, my lord, 11 may have been read more widely, perhaps. So, my lord, it has an impact. There is a commentary on Article 5. Well, this is I'm sorry I could not put it in the compilation, my lord. This is one of the best known, my lord, texts which explains the model law. And Article 5 pages are just taken out.
Section 5 is equivalent to Article 5.
Is equivalent. My lord, here every section is by and large equivalent to every article. That's the way we have copied it, my lord. Section 34 is Article 34. Section 9 is Article 9. Section 11 is Article 11. Section 8 is Article 8. By and large, my lord, there is great degree of similarity. So that's the basis. Article 5 states a simple but very important principle. Its purpose is to oblige the draftsman of the law, state any instances in which court control is envisioned in order to increase certainty for parties and further cause of uniformity. As noted by the Secretariat, the effect of the provision is to exclude any general or residual powers given to the court of the enacting state in statutes other than the model law. Lord, there are other judgments of this court, for instance, in Kandla, which suggests that Arbitration Act is a self-contained court. A judgment I'll also mention. So the purpose of introducing Article 5 was that you did not want to leave any general or residual powers outside this statute to the state court. And my lord, that's why 5 is prefaced by notwithstanding anything contained in any other law for the time being in force, which presumably may also include, my lord, the Stamp Act. Well, 5 is relevant for that purpose. Then your lordships will see 8. I'll come back to 8, my lord, or your lordship may see 8 now.
No, you are saying might exclude Stamp Act altogether, including the requirement of paying the duty.
My lord, I am not saying, I am not going to that extreme. I am saying, my lord, the Stamp Act will operate only at a later stage, not at the 11th stage. I am not saying, my lord, the Stamp Act is completely excluded. Certainly, my lord, the revenue of the state will have to be protected. There is no dispute about that.
We can come to section 7.
Section 7. Agreement.
You were going to 8, we thought.
7. Your lordship is right. 7. 7 is important.
7 is important.
7 in. My lord, 5 is extent of judicial. My lord, the idea is not to bring in through a side door in 5 other additional extra requirements. So that's the only, my lord, seems to be the purpose of 5, that it's a limiting factor. That's all I'm saying. I'm not saying that you completely, my lord, exclude anything. 7 is arbitration agreement. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have risen or may arise between them in respect of a defined legal relationship, whether contractual or not. Now, this language is taken both from the New York Convention and from the model law. This is a cut, copy, and paste of this portion. Most of it, Mulod, is Article 2.2 of the New York Convention. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. This is also well said. Arbitration agreement shall be in writing. This is an additional.
Can we read 4B?
4B. 4B is an exchange of letters, telexes, telegrams, or other means of telecommunication, including communication through electronic means which provide a record of the agreement. So you can have an arbitration agreement which is consummated in more than one document. So you can have two documents.
If that applies, you just recall you referred to Article 5C of the Stamp Act.
Yes, Madam.
Say that an agreement, an arbitration agreement, should also be stamped.
Should also be stamped.
So how would you apply it in a situation where the arbitration agreement
is in two documents, Manoj?
It's in maybe two or more documents.
Manoj, I would say
it says exchange of letters, communication through electronic means.
Right. So, Manoj,
which provides a record of it.
Short answer, Manoj. If there is no instrument, there is no tax. Yeah. So, Manoj, if there is no instrument, Manoj, there has to be an instrument.
Exactly.
So if there is no instrument, Mullah, then there is no question of any stamp act, Mullah. So
why these 2-3 collection of letters or
may become one or may become one
instrument.
It does say which provide a record of the agreement.
Which provide a record of the agreement.
You see the whole of it because it may have some
bearing,
exchange of letters, telegrams, other means.
Which provide a record of. So I send a letter suggesting an arbitration clause. Somebody else says, I agree.
So, Lord, would that be an agreement, an instrument?
Lord, whether it would be an instrument or not would have to be seen, Lord, under the
Section 214.
214. I am obliged, Lord. 214 would
whether it would be an instrument within the meaning of 214.
My Lord Justice Ravi Kumar is right, Lord. 214 is every document, whether it will fall within this mode, will have to be.
We'll have to see that.
We'll have to see that. My Lord is.
We'll have to.
I'll come back on this one. Whether it falls within 214, what happens if there are two documents which together form an arbitration agreement? How will 214 apply? In such
more, because you could have 2, 3, 4 more parties.
We could have correspondence going on.
Correspondence, you don't have to limit it to 2. You could have any number.
Because Manoj, this says every document by which the right is purported to be created, transferred.
When we saw it, we just wanted to point it out.
We says a document, electronic or otherwise.
Created for a transaction in Manoj, that is stock exchange and deposit.
Any other document mentioned in it.
Which would be agreement, Manoj.
But the duty value is still the same, 8 annas.
Duty, Manoj, in this case will be.
We are inquiring.
Duty is, I think, 100 rupees in most places.
Okay.
100 rupees. 8 annas is Manoj.
Amended schedule.
100 rupees.
There is a section 77A in the Indian Stamp Act, which has given the conversion. What is anna? 4 anna is 25 paisa, 55.
Yes.
The Indian Stamp Act.
Most of us would recall.
8 annas is
basic.
8 annas is 50 paise. 16 annas.
To answer your Lordship's query, the Indian Stamp Act has section 35. If it is on letters, then what? The answer is no, it's in the proviso. 3. Where a contract or agreement of any kind is effected by correspondence consisting of 2 or more letters, and any one of the letters bears the proper stamp, the contract or the agreement shall be deemed to be duly stamped.
So therefore, even in such a case, it has to be stamped.
Even in that.
Which section did you?
35 proviso C.
Section 35.
Therefore,
proviso
it have to be stamped.
Provided that C.
Of letters. So it would be an agreement.
It is an agreement, Manoj. There is no dispute.
So it would be an agreement.
In writing.
In writing, and therefore it would be an instrument. They just want
Section 214 defines the word instrument very largely.
Which includes agreement. Which
includes every document.
Absolutely.
Includes every document.
which gives rise to, my lord, any rights or liabilities.
If it is to be in writing, it will be a document.
It has to
It'll
be
be a document.
7.3.
Otherwise, it cannot.
7.3.
My lord, in fact, there are some very interesting developments there that now writing will, of course, include, my lord, emails, electronic.
That is included here.
That is now included.
That they've included.
That, my lord, they've now included in 2016. They've included it now. My lord, that is 7. Then your lordships come to 8. 8. Power to refer parties to an arbitration where there is an arbitration agreement. Judicial authority before whom an action is brought in a matter which is subject matter of an arbitration agreement shall, if a party to the arbitration agreement, any person claiming through or under him, applies not later than the date of submitting first statement. Notwithstanding, my lord, this is now new. Notwithstanding any judgment, decree, or order of the Supreme Court or any court, refer the parties to arbitration, and this is the relevant phrase, my lord, unless it finds that prima facie no valid arbitration agreement exists. So the test in 8 is of validity. How this has come to be, my lord, I will show from the history.
Vijay Dhodia has equated both.
Has equated both, my lord. That also has to be seen as to how much your lordships wish to equate both or not, or to what extent it is to be equated. That's another. My lord, in fact, there are 2 judgments in Vidya Dholia. There on some portion, there appears to be some degree of inconsistency between the 2 judgments. Those I have also mentioned. You know, there are some issues where something is said in the first, something is said in the second. Normally, my lord, we don't look at all the judgments as lawyers, but once one has to assist your lordships, both judgments have their own nuances. We'll just point it out. My lord, if we then could come to 11. My lord, what is interesting about 11 is, if you want to show 11 from, my lord, unfortunately, the book shows 11 as if 6A has already been deleted, but it has not. So that problem is
notified.
It has not been notified. Your lordship is right. It has not been notified. So today, it's there in the footnote. One thing I want to show, my lord, before one reads 11 is that 11 now uses the word High Court or Supreme Court. Earlier it used Chief Justice or designated judge. Now it uses High Court, Supreme Court. But, my lord, the High Court and Supreme Court are not the court mentioned in section 2. 2(1)(e) is different. High Court and Supreme Court is differently treated, my lord, in section 11. High Court or Supreme Court is not the 2(1)(e) court. It may not make any difference here, but it is certainly there because, my lord, the court, 2(1)(e) court is usually the court of the district court or the High Court, which has the subject matter, the jurisdiction, which has no original site. But here, my lord, specifically, court has not been used. The phrase has used either High Court or Supreme Court. For instance, my lord, your lordships always have the situation that under section 11 there is no appeal. So it is always SLP. Your lordships are flooded with section 11 SLP. Because the role here was not to be, my lord, as we understood it. May I now read, my lord, 11.6a. 11.6a is the bottom of the page. The Supreme Court, or as the case may be the High Court, while considering any application under subsection 4, 5 or 6, shall, notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of an arbitration agreement. This is the language.
Slightly different from 8.
Different from 8. 8 says validity. This now says
prima
facie validity. This now says confine to the examination of the existence of the melody. Each section has a different phrase, and somewhere there is a reason for that. So, my lord, I have a number of. Then your lordship will also see 11.6b, which is the delegation. There's that one. 11.6b still a designation of any person or institution by the Supreme Court, case may be the High Court, for the purpose of section shall not be regarded as a delegation of judicial power by the Supreme Court, High Court. This is still there. This is so. Supposing now this is notified, or even if it is not otherwise notified, the appointment can be made by any ABC, ICA.
What is the reason for it not being notified?
My lord, I think possibly the government will give an appropriate answer. My lord, the reason may be that this was part of that high-level committee Justice Sri Krishna report, and a number of recommendations were made, including the Arbitration Standards Council of India. There was some resistance to that, but now, my lord, all that has been ironed out, and I believe Justice Hemant Gupta has been appointed to this body, and they have to actually accredit institutions.
That's right.
So until and unless there is a body which actually says institution A is appropriate, institution B is good, institution C is bad, maybe they are waiting to.
The number of high courts, I think, section 11 applications are kept pending. This is what I get told.
Oh Lord, I have recently appeared in a case where a section 11 application of Jammu and Kashmir High Court has been pending for the last 11 years.
11 years.
11 years, despite 2 orders of this court to dispose it off. Oh Lord, it's an issue. Section 11 pendency earlier.
In a suit, it would have been over.
At least it would have started. I don't know whether it would have been over. At least appointment is the first step.
Absolutely.
I think we don't perceive the way this act works. The theory is that arbitration tribunal has the first bite of the cherry, but the first look. But the last look is always with the court. It is not that the court is being excluded, Mullah. There's a very nice passage of Justice Thakkar, paragraph 96 of the dissent, where he explains it and he calls it chronological priority. You first go to the tribunal, let them look at it. They have the benefit A of time, which the court doesn't have, B, my lord, of evidence, which again, my lord, puts pressure on the court. Let them take a call. Nobody is saying that because the arbitrator has decided I have jurisdiction, that's it. Then there is always court control. Look at the stamping situation, my lord. Today, a section 11 judge has to decide on stamping. Let's take a practical example. He will say that this is duly stamped. He will say, no, this is inadequately stamped. Either you decide it yourself, you may get it wrong. In the present case, my lord, there is a dispute as to the quantification of the stamping. They say, no, it was just an agreement, but I have coughed up 8 lakhs anyway to get the matter going. So, my lord, if you push these disputes to the section 11 judge and you expand his jurisdiction, he is already overburdened. My lord, the entire purpose of arbitration is to take the dispute out of the system and settle it somewhere else. It is not that the court is losing, my lord, its supervisory jurisdiction. Supposing section 16 holds, no, it's adequately stamped. Challenge in 34. You say the document is inadmissible. How dare you act on it? Have it set aside. Or you have misconducted yourself because you did not impound the document. You should have protected public revenue.
What if it is not stamped at all? All disputes where it is insufficiently stamped.
If it is not stamped at all, what will happen? The day the document arrives, my lord, I also said in the day the document arrives, my lord, I will then have to take a call. Either I will impound it, I may decide it myself, my lord, I will be in a better position to decide. I'll have the benefit of the arguments of both, or I can send it to the collector. In the meanwhile, pleadings can be completed. 6 months is saved. If you do the same thing before a high court judge, my lord, practically, my lord, I'm saying, the next date is 6 months. The next date after that is 6 months. The 1113 says, my lord, I almost, my lord, I started laughing when I read it. It says application under this section shall be disposed of within 30 days. My lord, I asked myself, which application?
arbitration is to be concluded in 18 months.
In 18, well, no, that is possible. That is still happening.
Unless you appoint the arbitrator, how will it proceed?
Yes, yes, ma'am. But
If my
30
complaint
days.
is not registered.
No, that is not.
No, but if my complaint is not registered
You can't
in
proceed.
the first instance, what to say of the conclusion?
They have amended it. Because 18 months is from.
That's correct.
From pleadings.
The legislature thought that it must be some
start,
months to start with.
My lord, the whole, and that, my lord, in fact, that is why in no other country of the world, in no other country do we have this Section 11 problem.
That's one thing.
I found one judgment, my lord, from Bermuda of 2006 and one judgment from Hong Kong of 2008. That's all.
Only one thing. This is a additional window available as a mechanism for adjudication of the disputes expeditiously.
Right.
Arbitration.
Yes.
The law framers thought at given time that the regular mechanism available may take longer time.
Yes.
And commercial disputes could not be decided in the time framework. So let us have a different window.
Correct.
Now, our request to you is, please examine. If you go on the theory of unstamped, not sufficiently stamped, insufficiently stamped, to my understanding, any agreement or a document which you call the legal term, which creates rights or liabilities over the parties to the commercial agreement, fairly good, stamped, because it has to be placed as a document and to be exhibited at the stage of adjudication. This is in reference to an arbitration but in adjudication. The parties are not on the loggers for adjudication. This or so on. We only coming forward to have the arbitration of the dispute.
Right, my lord,
This
this is
is
not
not a
substantive rights and liabilities.
Yes.
It's just an arbitration.
This is not a dispute. This term of arbitration is only coming both the parties to a common stand that adjudication may take place in reference to the disputes in question. So our question to you is, as you said, it has to be stamped. What I feel is,
it has
look into it.
It has to be stamped,
It is in
but
reference
not by the court. My lord, it has to be stamped when the substantive disputes come before the arbitrator, then it has to be stamped. Because once it comes to the arbitrator, my lord, he can't get out of it. It will have to be stamped. Because of the language of 35, which covers a person appointed by consent also.
So ultimately, it will really boil down to one thing.
Yes, ma'am.
In the Section 11 application, when the agreement is produced, and the court takes a look at it and finds the existence of the agreement,
right,
whether it amounts to attracting Section 35, the bar under Section 35,
or not.
Right.
That's it.
That is the only thing.
That, according to me, no, my lord, because 35 bar is only qua admissibility.
Admissibility as evidence.
And evidence. Admissibility of a document. It shall not be admissible
not
in
attracted by itself, it doesn't go to the validity of the agreement.
Right. So, my lord, if
and it is curable.
And is curable. So, my lord, existence has to be read. I would respectfully submit. My lord, existence can be read like this. It can be read like this.
That's right.
You can read existence in whichever way you want. But the section uses existence. Section 8 uses validity. Section 16 uses existence, validity, jurisdiction. Section 45 uses null and void, inoperative, incapable of being performed. It's a different test. That's a wider test. So, my lord,
So what you're going to say is, apparently, from what you're saying, an unstamped instrument is not void.
It's not void.
It is enforceable.
Right, subject to admissibility.
It is not voidable as other instruments, agreements are not voidable in the sense.
It's not voidable.
Merely because it is unstamped.
It's not voidable. No, it's a valid document.
All that it suffers from is a curable affliction.
That's right.
Namely that it is not either
sufficiently stamped or stamped at all.
Insufficiently stamped.
And that is a problem, a headache for the gentleman down the line. Please do not invite this problem on yourselves as the court.
And therefore, neither because the fact that it is not stamped nor exceptionally stamped will detract from it existing.
From its existence, and please appoint the arbitrator and he decides on the stamp.
It is not ab initio void.
You cannot say it does not exist.
That's the argument. No? That's the actual, and therefore, my lord, 33. How do I get out of, my lord, 33 and 35? My lord, 33 requires me as the judge. My lord, I'm for a moment, my lord, pushing myself up and elevating myself up to a high court judge, my lord.
Can be in moot court.
Sorry, my lord.
Can be in moot court.
Include court, my lord. So, my lord, so supposing the court looks at this document and finds the existence of an agreement, I appoint, my lord,
When court looks at this document,
right,
to the court, what is the character of this document?
my lord, the court has to satisfy itself.
No, the moment everything we can't look at.
Right, my lord.
So
what is the character of the, may I phrase it differently? What is the scope of my inquiry? The court's inquiry. What is the scope of its inquiry? Does the scope of the inquiry, my lord, I am suggesting that the legislature has deliberately put a limit to the amount that the court can examine.
So that will again take us back to the scope of the proceeding under section 11.
Right.
As to whether it involves letting in the arbitration agreement.
Right, my lord.
Into evidence.
Yes, your lordship is right.
If it does not involve, taking the arbitration agreement into evidence, but it only involves looking at it as to whether it really exists.
That's right. I will put it in a different way. That is one way of looking at it. Please see 33. What is the scope? What is the judge supposed to do under 33? He is to examine whether it is properly stamped on. I am suggesting, before you get to 35, you clear the hurdle of 33. 33 is one side of the coin, 35 is the other side of the coin. 33 is the judge, the section 11 judge gets the document. Normally, absent 11.6a, he is to examine this document to see whether it is stamped or unstamped. That's what I am saying, that in view of the language of 11.6, this part of the scope of inquiry is not required to be done by him. If 33 does not engage, my lord, 35 also does not engage, because 35 is the same thing you have to do in 33 and 35, namely satisfy yourself as to whether XYZ document is stamped or not stamped. So, my lord, that inquiry is not to be done by him.
What is the position under the 1940 Act?
My lord, under the 1940 Act, my lord,
there also, you would have had this.
My lord, there was no, my lord, there you would have to file the agreement in court. You would have to file the agreement in court.
So there also.
Section 20.
Yes, section 20 you have to file, and my lord, you would have to judicially apply your mind and then decide which disputes are to be referred.
So
and
other decisions.
My lord, there are decisions under section 20. I can come back to that. My lord, section 20. In any event, my lord, under I could find a couple of judgments, old judgments, which say that under the old act, my lord, the agreement had to be stamped. So, my lord, that was the procedure there. There is one very 2-page 1800 Calcutta judgment which is there. But there, my lord, the process was different. The court would define the scope of the reference. The court would identify the issues to be referred. My lord, that model is gone. Now we are on a, my lord.
No, we are only on that other limited
limit. I'll have
a purpose of.
So, your lordships were looking at.
Mr. Banerjee, would you be correct in our understanding that at the stage of exercising jurisdiction under section 11,
correct,
an unstamped document may have its own consequence, may not be admissible in evidence,
right,
but it can certainly not impair the triggering of the process of arbitration?
Yes, because, my lord, it exists as a matter of law.
That's
it
right. So,
exists. It is not, my lord, a
judge is not going to have such a wide-ranging thing, but the trigger can definitely.
The trigger can go. My lord, let me be, my lord, absolutely frank. There, it is. Your lordship can take both views. It is eminently arguable the other way, my lord. I had great difficulty coming one way or the other. But if your lordship sees the evolution of 11.6 and 11.6a, it was never the intention to increase the scope of inquiry of an 11 judge, because effectively, my lord, an 11 judge, though we would not like to say it, is effectively, my lord, substituting for an institution. He is really a stop.
You can do the research work. This 6A of section 11 earlier came to this court. I am the author of that judgment. It arising from an insurance.
Yes, my lord. Anti-cards.
Then Justice Rohinton
Overruled it. Overruled it.
He again defined 6A.
Right.
My view was that as long as the judicial intervention is there,
right,
some judicial discretion has to be left.
Right.
Put it into
That was anti-cards. Your lordship is right. That
Right.
was that has
Very
been
important here is that the Rohinton's judgment
Mayavati trading. It's in the compilation.
is in compilation.
It's in the compilation.
And I think 6A has been elaborately put into
6A were not discussed in Vidya Drolia in great detail. I'll show you, your lordship, that also.
That is also 3 judges.
That is 3 judges. Mayavati trading is 3 judges. I'm relying on Mayavati trading one.
Rohinton is the author of that judgment.
Yes, one paragraph I will show of that also. That also is there in the note and the compilation. That's there. So, my lord,
So apparently 6A has already been interpreted by this court
sorry,
in totality. What is the scope and ambit of section 6A of section 11?
11.6.
What is stamped or unstamped?
My lord, 11.6A has been looked at in some detail in Vidya Drolia in the context of, my lord,
Document is not probably stamped.
No, in the context of subject matter arbitrability. In that process, my lord, 2 paragraphs of Vidya Drolia, Justice Khanna appears to have followed Garwari.
Earlier.
And that earlier SMS.
SMS.
My lord, SMS actually,
SMC.
SMS, my lord, frankly, SMS is so far in the past and it is pre to 2015, my lord. Whether your lordships will want to go into it as to whether it is, though the 3 judges overruled it, my lord, specifically, whether your lordships are required to go into it or not is a debatable proposition, because now post 2015, my lord, really the issue is.
No, SMC took the view that for the purpose of section 35, separate instrument, though it may be, cannot be used for any purpose.
Any purpose whatsoever.
Contrast to the section 49 of the registration.
Right.
That is how it went.
Well, there was a difference in unregistered document and then unstamped document. That's 49 provided.
Exactly. Any purpose, collateral purpose.
Collateral purpose. But Mulot, that was at a time, please understand Mulot, SMS at a time pre-2015 governed by SBP.
That's right, that's right.
Mulot, we are still in the SBP mindset. Unfortunately, Mulot.
6A has come up.
Though 6A has come, we are in the SBP mindset. Mulot, I argued SBP on the losing side, Mulot, and I cannot conceive of more hostile bench. Justice Thakkar in the entire 7 judges, Mulot, hearing did not say a single word in support, Mulot. And I was much younger, Mulot. The judges essentially told me that why are you insisting on a narrow interpretation of section 11? It will mean more work for you. You can argue your section 11 here and you can argue it before the arbitration there. So, Mulot, anyway, one has some feelings. That's of course history, Mulot. But still SBP is being followed in some of these judgments. And that is a problem because 11.6A specifically was brought in to tide over SBP. Despite it, Justice Khanna has cited SBP. Justice Nariman has cited SBP in Garware. There are some areas your lordships will have to iron out the creases. Though the issue appears to be very narrow, but essentially, my lord, the issue is what would you want? What would you, the Constitution Bench, want an 11.6 judge to do? So all the High Court judges are waiting, my lord, as to how to deal with it. So it is not only stamping, my lord. It is primarily stamping, but it is not only stamping.
It is an approach.
It is an approach. So that is a question. My lord, one last section I want to show. So, my lord, 5 points on section 11. There is a non-obstante clause.
See, there may be certain instruments which may not be required to be stamped.
Yes, my lord.
37 section, the scope of revision under section 61
Correct.
There, the question is whether it is duly stamped or not required to be stamped.
At
That
all.
also is a question.
That's also a question.
61 says
16.
duly stamped or not required.
Required.
Just give the evidence act.
61. Provision.
Provision, but this
That-
discussion or
Discuss-
whether that particular instrument is required to be stamped.
Correct. Correct.
If it is not required to be stamped, then there is a question of not duly stamped. There is no necessity at all.
When section
We would submit it is not evidence
That is-
being admitted at the stage. Well, not 11 is, well, not, I would put it in this extreme fashion. 11 is not a normal court. 11 is not your lordship sitting in their normal jurisdiction deciding issues. That's not the scope of an 11.6 application. Though now long judgments are, that was never the intention. I'll show the intention.
But now some adjudicatory function.
Now it is, my lord, that is the question as to where to strike the balance. Moment
as it is.
As it is. The moment your lordships increase the adjudicatory functions, the consequence is that arbitration grinds to a halt on day one. Because courts are inevitably under pressure. 11 applications, I'm not saying extreme cases like J and K, but the reality is, my lord, moment one has to adjudicate, one has to find the time, one has to devote the resources, and, my lord, prioritize. Why should commercial matters be prioritized, for instance, my lord, over criminal matters? May not be, so that it is pushed to the back. But then the entire edifice falls. So, my lord, it has to be looked at from a broader perspective. My lord, I am not, fortunately in this case, I am not on that side or on this side. My lord. The lordships will look at it from a, my lord, from the perspective.
not lose the case.
So I get
That's great advantage.
great advantage. So it's a very liberating, my lord, experience not to have to commit to a particular position. So, my lord, just to, my lord, summarize 11 in 5. There's a non-obstante clause. Its scope is narrower than the recommendation even of the Law Commission. My lord, it removes SBP, lock, stock and barrel. My lord, the language your lordship has seen.
Perhaps even narrower than 8.
It is narrower than 8. In fact, that's another issue as to whether, my lord, whether you can equate 8 and 11. So actually it is narrower than 8, my lord. 8, my lord, I must confess, I am a little less, my lord, gung-ho about 8. But certainly, my lord, 11, I feel that this is a matter which certainly courts should not be, my lord, burdened with. So, my lord, 11 is narrow. It is a amendment which has been made. And, my lord,
Continue tomorrow.
please.
How much time is supposed to be?
My lord, I have got through half my note. I try my best.
You can't take a middle path. You take either this way or that way, which according
My
to
lord, it will take a little bit of time. My lord, it will take.
bikers can't have a middle path.
Well, it will take a little bit of time. My lord.
My lord, this will also have an impact on the section 9 point, my lord. My lord talked about the approach.
No, but one thing is very clear, subject to what you argue.
In the morning.
Yes, it will continue in the morning.
Section 11 is given an interpretation, an adjudication. Then the very purpose is frustrated.
But my lord, what the impact will be on section 9 also, my lord, is something that we would want the honorable court to see.
That's not on reference, I think let's see.
That's right.
Thank you. Chal. 30, madam, I can't go in.